Yeah.
Item 1.
This is a case. Your Lordship disposed of the matter on 10/11, direct on the recommendation of the BO, directing to change the name of the school. Your Lordship will make and see.
Correct.
Now, the opposite party, they have filed a review petition that the petitioner in that writ application, they have suppressed material fact that a civil suit on the same said ground is pending. That was not brought to your Lordship's notice.
How that civil suit becomes infructuous. Change of name is a matter of public law. Suit is maintainable is one thing. But how that suit, who appears?
The
in that case.
yes.
For the petitioner.
Yes, my lord.
In the petitioner in the writ application.
Writ petitioner. My lord directed to change the name of the school. There was a recommendation of BO. On the basis of the recommendation of BO, the name of the, on the hearing of the Lordal Council for the opposite.
No, who has filed the IA?
They are not there.
They are not here. That the whatever order is made will be subject to outcome of the suit.
Suit has been dismissed.
Dismissed.
Yes, no.
Then what is that?
This has been withdrawn.
I have no instruction whether suit has been, but
No, he is saying he has
Yes,
withdrawn
yes, I am for the petitioner. Suit has been after disposal of my lord's
right up.
no, your Lordship may, we have also, your Lordship may call this whatever.
Have you filed the application?
I have filed on behalf of the state, I have filed a IA for extension of time.
Time will give you.
That your
But other
Lordship,
application you cannot oppose. You are not the applicant.
no, I am not done.
The application in IA number so and so seeks recall of the writ order inter alia on the ground that the petitioner had suppressed the pendency of the suit. In CS number? CS number so and
Yes, sir.
just do that.
49 by 2018,
49 by 2018.
pending before the,
Pending on the file of. Sorry.
in the Court of Additional Civil Judge, Junior Division, Khandapada.
But counsel for the petitioner submits that the suit also has been withdrawn and therefore the substratum for maintaining the application has withered. First off, I agree with this and therefore the application is rejected. Next point. I cannot learned counsel, Mr. Lenka,
Not your Lordship's board, I filed with the IA. Yesterday I filed.
moves an application seeking extension of the period for accomplishing the writ issued in the petition. How much time you need?
We have prayed for 8 weeks because we have already moved the state government.
We have sought for by 8 weeks. 8 weeks. First off, there is no objection from the
1 month.
counsel for the petitioner for according the IA, according the relief sought for. First, in view of that, a period of 8 more weeks is granted for reporting compliance with the writ, failing which, in the next level of the litigation,
Your Lordship direct.
heavy costs will be levied on the officials who will be responsible for broking delay.
He told your Lordship directed 1,000 rupees per day.
So 8 weeks we have given now. In addition to that, heavy costs again. Yes. Otherwise, the officers will not work at all.
Obligation.
Yeah.
Item 2.
Yes.
The cover matter similar to minor disorder.
Show it to Brother Lenka.
Yes, sir.
There is no such culture in your country. Sharing the judgment, etc. No such culture.
No, yes,
This is the
culture
great
is there.
land of Jagannath. No culture of exchanging the views, exchanging judgments, etc. Then what I should go and tell Bangalore people about you? I will go and tell the truth. What kind of war? This sentence you have to complete. Huh? Ask someone. I'm very sorry to say this. I am under the impression you are all cultured people. You don't share your rulings. You don't share your applications. You don't share your copy of the petitions. What kind of bar? neither quality nor morality. Is good.
Item 3.
Mr. Mishra, I'm sorry to say this. Every day I'm coming across such cases. They say covered by the judgment. First, they do not say what are the facts. They covered by the judgment. They're not a tea shop.
Yes.
They should say few words.
Yes,
What are the facts? These facts are covered by the judgment. I have given a copy to the government advocate.
similarity has to be justified.
Oh.
Similarity has to be justified.
Why can't you pass a
Problem is-
resolution? Why can't you?
Problem is that the
people?
government council change frequently.
No, that's not the
That
case.
is the reason why probably.
No, if that is the
I do not.
explanation,
I do
but you
not.
should tell the members of the bar
Yes.
that they should upgrade their moral levels.
Yes, yes.
General,
At least-
always we should.
So for the rulings
in
and also
advance.
especially the references are to be shared positively. That is to them.
Next.
Item 3.
May I please? In this case, petitioner seeking minor, lecture through pay scale and reader scale in the light of Loknath Behra case minor. This is correct.
You have changed the factors.
Minor. I have already corrected.
You have served the court.
Minor.
Yes.
Obliged.
Next.
Item 4.
Item 4 is a block grant pension malad. There is a headmaster of ME school malad. Block grant pension, extra copy we served and OP5 notice malad.
Yes. Issue emergent notice. Mr. Lenka is requested to accept notice for 1, 2, 3, 4. Emergent notice to 5.
Item 5.
May I please, Your Lordship?
Yes.
My Lord, I have filed this writ petition. My Lord, the petitioner's
Father's
father's
name.
My Lord?
Father's name to be rectified.
Yes, my Lord. Only spelling mistake is there, my Lord. Zakir Hussain instead of my Lord, MD Zakir Hussain. Hassan.
Can you tell the person by this name held one particular office in the country?
Yes.
Who was he?
My Lord, OP number 2, my Lord.
No, President of India.
President of India. Yes.
But your Lordship may kindly annex page 17.
Let them.
Page 17. The
Certificate.
birth certificate he has received on 2008/3/2024,
Correct.
where his father's name has been mentioned Zakir Hussain.
Correct.
Then your Lordship may see
No,
page
now he is saying what is mentioned in the birth certificate is not the Vedic truth.
birth certificate obtained in 24.
Correct.
But the correction he wants to make, that was issued in 2010.
Very well. For that, he need not. Section 13 is not applicable. Section 13 is applicable only when it relates to date of birth or date of death. Of Births and Deaths Registration Act 1969.
Yes, sir.
It doesn't apply to such cases.
I have filed the division, my Lord, bench decision, my Lord. Similar matter.
Similar matter.
The grandfather's name is mentioned, but father's name is not mentioned there.
Anyway, father's name he is saying. My father's name is like this.
Your Lordship.
You have given a revision.
Division bench, my Lord. Division bench decision.
I given. It's covered by judgment.
My Lord.
What it says.
His grandfather's name is mentioned there, but father's name is not there. So in this regard, my Lord, the Honorable Court direct to correction the father.
But this is correction of name.
Correction. Here, my correction, khali spelling mistake is there.
Spelling mistake.
Yes, ma'am.
But not non-mentioning of name. Then judgment is not applicable.
Not spelling mistake. Zakir Hussain and Mohammed Zakir Hussain.
MD.
He wants to change from Mohammed Zakir Hussain to Zakir Hussain.
Therefore, it is not the introduction of the name for the first time. Already name is entered. A particular word is missing.
He wants to delete that Mohammed.
That's well, which is the representation.
No representation.
You give a representation for changing the names. How they will know what the name should be changed, what is the basis. All right. Purpose.
Representation to 3.
No.
3 and 4. 2 and 3.
Petition prayer reads as that. Next paragraph. Learned counsel for the petitioner submits that some wrong name of the father having been mentioned comma. The same needs to be rectified in the school certificates and
Mark sheet.
mark sheets as well.
Not school, board certificate.
Huh?
Board certificate. Board of Secondary Education.
No. High school examinations.
That is issued by the Board of Secondary, not the school.
In the high school examination certificate issued by the board, HSC board,
Yes.
issued by the HSC board, and in the provisional mark sheet of the petitioner. First off, at the outset, learned AGA Mr. Lenka submits that unless a representation is given, comma, a writ of mandamus does not lie. First off, this is ordinarily true. First off, counsel for the petitioner agrees that his client would be advised to give a representation for accomplishing the task, and that if one is given, the same needs to be decided at the earliest, so that academic and non-academic difficulties would not crop up in the life of petitioner. First, this is appreciable. Next, in the above circumstances, petition is disposed of, reserving liberty, as mentioned above. First off, if a representation is given by the petitioner, supported by evidentiary material, comma, the same shall be decided by OP number
2 and 3.
How both will, they will not
So,
sit against the table.
OP2, my lord.
OP number 2,
Yes.
2, within an outer limit of 8 weeks. 8 weeks. First of all, delay shall be viewed very seriously. First of all, contentions kept open. Next.
Item 6.
Madam, this is a case of appointment under rehabilitation assistance scheme, Lord. And the death will occur on 6/4/2012, Lord. And the petition was applied on 22/2013, Lord.
Rejection.
As per Rule 8, Lord, of the Rehabilitation Rules 90, Lord, upon receipt of the application, the appointing authority should send the requisition to the concerned collector of the district where the family ordinarily resides, my lord. He didn't do that, my lord. And after that, my lord, now by the annexure 8, my lord, without sending the same, he rejected my case by the annexure 8, my lord.
Block education officer.
My lord, block education officer.
Who is the authority, Mr. Lenka, to take a decision in
DO.
The DO, my lord. DO.
DO?
my lord.
How BO will take the decision?
There must be, this is arising out of another REIT application. And BO was directed to consider it.
Consider, he should have said, I don't have jurisdiction. Consider does not mean he can grant or reject. We'll set aside this order, remit the matter to the DO.
My lord.
You let me call it next week after.
Now, issue emergent notice. Mr. Lenka accept notice for the OPs. Since short point is involved, call this matter a week after next. Okay.
My lord.
Item 7.
May I be pleased, my lord? I am in virtual court, my lord, at Kendrapada, my lord.
Yes.
My lord, the fact of the case is that the petitioner, namely Debashish Behera, was born on 14/8/2005, my lord.
Have you made the application?
My lord,
To whom you have made? On which date you have made?
Before the toss,
before Tahsildar Deravishi, my lord, OP number 1, my lord.
Who should give? Who is the birth registrar of births and deaths?
Birth they registered, my lord, Tahsildar, concerned Tahsildar, my lord. Executive magistrate, that is called executive magistrate, my lord.
no,
Huh.
that is the CDMO.
Under which there is no.
I have already submitted, my lord, all the documents, my lord. And
All right.
to my lord.
Correct. But under which section Tahsildar is the jurisdictional authority? Just show that.
The executive magistrate, my lord, authority, according to the death and birth miscase, my lord.
There is a registrar of births and deaths, na?
My lord.
How the Tahsildar is not show that Tahsildar is the
No,
authority.
here, his case is here, my lord.
Huh.
He has filed a miscase before the executive magistrate, that is the Tahsildar Kendrapada, for registration, my lord. Your lordship may see page
He has
8.
to approach JMFC.
No,
My lord, this is the present position of law, my lord. Executive magistrate is the power.
Executive
yes,
magistrate.
yes, here also.
Which is that? Read section.
First,
Read the section. Which is your? Where is your book? Where is your law book?
my lord.
You have come to the farmhouse without a bullock cart.
Sorry, my lord.
Which is that?
Section 5, my lord, birth and death miscase in 1969, my lord.
Section
13, subclause 3.
13 amendment. Right. So after an electoral amendment to section 13. Where is that? 13. What 13 reads? Any obstacle for payment. But that means any but delayed the permission given to register 1 year shall be subdivisional magistrate.
So, my lord, the law has been amended in the meantime, subdivisional magistrate in the case of subdivision court, but the other executive magistrate and have the power and Tahsildar concerned Tahsildar have power. Amended, my lord.
Anyway, consider that representation. In the event he is not the authority, the authority, I am not the authority. He should tell the citizen, this is the authority, to him I am sending you. That should be the approach.
My lord.
Short grievance of the petitioner is reflected in the prayer. First of all, counsel for the petitioner argues that the Tahsildar, being the competent authority under the amended provisions of section 13 of Registration of Births and Deaths Act 1969, he is bound to grant or reject the application depending upon the merits of the case. First off, he further submits that application of the kind cannot be kept pending eternally in the cupboard of the Tahsildar to the detriment of the city. First off. Next paragraph. Learned counsel Mr. Lenka, in his usual fairness, agrees to instruct the Tahsildar to look into the grievance of the petitioner in a time-bound way if all contentions are kept open. First off. He also assures the court that in the event Tahsildar is not the jurisdictional authority, the said application shall be transmitted to the jurisdictional authority on a war footing. First off. This is really appreciable. Next paragraph. In the above circumstance, it's 6 weeks. So can solicit, etc. Okay.
Item 8.
Next.
Lordship, the petitioner is a slum dweller, my lord, who was recognized as a beneficiary of the Odisha Housing for
So
All.
allot a dwelling house to you.
My lord, yes, I was selected as a beneficiary.
Where is that selection?
My lord, the list is at page 15, my lord, annexure 2, my lord.
This is prepared by whom? Under which law?
My lord, the scheme, my lord, Odisha Housing for All Policy 2022, my lord, for urban area.
22. Where is your name, brother?
My lord, S. Srichandan, my lord. My lord, I have
Serial number?
serial number 106, my lord, that is at page 19, my lord.
So how these similar matters are treated by the judges of this court? Or for the first time in the history, this case is coming before Justice Dixit.
Lord, I have already given a representation, my lord.
Let them consider that.
They have not yet considered that, my lord. And now, my lord, they're threatening to also evict me and demolish my dwelling as well.
You are already in that dwelling house.
I am in that dwelling house, my lord, but
That itself needs to be allotted to you.
no, my lord.
Some other.
No, my lord, the redevelopment was announced, and as per this policy, my lord, I have the relevant portion of the policy, my lord.
Why you are not made it part of the pleadings? Statute need not be. But policy, government policy should be made part of the pleadings, na?
Yes, my lord. My lord, may come to paginated page 18, internal page 31, my lord.
5 point?
5.3.13, my lord.
issuance of entitlements on the basis of this services. Who appears for
BMC and VTA.
Mr. Lenka?
Notice has to go. VTA, Mr. Dayanand Mahapatra, senior advocate. The BMC had to notice to.
Why notice? Then we can direct them to take a call on the matter if it is pending.
Pending, Annexure 3 is pending, that may be disposed.
That's what. Why notice also need not be issued to them. For it's an innocuous order. An order to pass order on the application. Okay. The short grievance of the petitioner is as to non-consideration of his representation for allotment of the site.
Only I pray you not that without.
Dwelling house.
My lord.
In terms of the state government policy published a wide notification dated 30 November 2022. First off, a copy of the notification dated
30th November 2022, my lord.
Your representation.
Representation dated, my lord, 14/11/2023, my lord.
A copy of the representation dated
14/11/2023, my lord.
11/2023 is pending on the file of
Opposite party number 2, my lord.
OP number 2. Go to the cost item.
To Bhubaneswar Municipal.
First off, learned AGA Mr. Lenka submits that it is OP numbers 2 and 3 who have to take the decision in the matter, and that the state has no much role in that. First off, be that as it may. Next paragraph. Where an application is pending for grant of statutory benefit in terms of state policy, such applications cannot be kept pending eternally, covered of the offices to the detriment of citizens. First off, that would cause misgovernance, which the Constitution abhors, ABH4RS abhors. That is how Article 315 has been structured as expansively interpreted by various high courts in the country. First off, next paragraph. In the above circumstances, this petition is disposed of, directing OP number 2
Yes.
to take call in the matter on the subject application in accordance with law within a period of 8 weeks, if it is already not disposed of. First off, till consideration takes place, no coercive action shall be taken against the petitioner.
Duty obliged.
Item 9.
Conditions kept open, it is open to solicit, etc., etc. Registry to send a copy of this order to OP numbers 2 and 3 by speed post immediately. Next.
My lord,
9.
this item 9.
One sentence you have to add. Since the prayer is innocuous, that is, for an order to pass an order of the pending application, notice to OP numbers 2 and 3 is dispensed with. Sentence somewhere you should just structure that judgment.
Both the
Yes.
cases. Both the cases.
Both the
connected.
cases. Same. Just look at the date of the representation.
A one less mini health center was constructed.
Primary health center like
Primary health center. It is
Mini health
mainly
center.
a wellness center. It is known as wellness center.
wellness center.
A
Who
doctor-
established that?
Government.
Government.
And the health and the family welfare department established. 9 months back, it is not being made operational. So villagers have approached my lord.
Why, brother, activate that hospital? That
It's a nature of PIL, man.
all right.
And-
But no, not a PIL. He may go to the health center, wellness center.
It's a PIL.
No.
And
No, not a PIL. Because they want assistance from the wellness center. Suppose a person comes to, I'm giving an example to you. A person comes to the court saying that I'm not being allowed to take a morsel of water from a reservoir. Is it a PIL or individual interest? Similarly, He is saying, I want to go to the wellness center to activate it. What for? Otherwise, the devils will enter. Then eviction proceedings will not be available. You can take eviction proceedings only against human beings. The devil will contest saying that the eviction law is not applicable to
Because they have not filed any
representation.
With that limit.
Petition prayer reads as under. First, counsel for the petitioner submits that when a wellness center has been established by the state government by investing huge sums of huge funds,
24 lakhs.
that is 24 lakh, rupees 24 lakh, the same cannot be put dysfunctional for indefinite period of time. First off, he submits that unless court intervenes, nothing would move in the state. First, next paragraph. Learned DGA Mr. Lenka opposes the petition contending that it has elements of PIL and therefore this court has no jurisdiction. First off, I do not agree with this. Since petitioners want to make use of the wellness center in question as rightly submitted by their counsel. First off. However, Mr. Lenka is justified in telling the court that the petitioners should give an appropriate representation to the jurisdictional authorities before knocking at the doors of this court. First off, with this proposal, counsel for the petitioner is agreeable. Next paragraph, in the above circumstances, petition is disposed of reserving liberty to the petitioners as indicated above. First off, should one such representation be made, the same shall be decided and appropriate action would be taken to activate the wellness center in question on a war footing. First of all conditions are kept open.
OP number 3.
Whoever, let it be to all. You give representation to all the three. Next.
Item 10.
You wanted to say something.
Item 1, that review petition, your lordship.
As you were not here, we have passed the order, open order it is. If you want, you can recall that. Next.
Item 10.
No question, because I have passed the order. People will be looking at me. It is online. If you have any grievance, make application, I will consider. Next.
Item 10.
Your Lordships, on behalf of C. Vidyabhushan, the counsel is unavailable today due to his illness. Your Lordship may urgent the...
Let's start, daughter. Turn the pages. I will help you.
Your Lordships, I...
Give over. Turn the pages.
I beg for your pardon, Your Lordships.
I will pass over. I will not damage. I will pass over. Turn the pages. What were you doing in sitting the court when matter was you wanted to take adjournment? You should have turned the pages of the... You should always have a book in your hand or file. You should turn the pages instead of whispering something bad thing in the ears of the neighbor. Is it? You take that file, I'll call you again after 5 minutes. Just look it.
Obliged, Your Lordship.
Mr. Lenka.
Yes, ma'am.
Let her look in. Yes.
Item 11.
My lord, the petitioner is acting as assistant teacher in Bhubaneswar. He has given a representation for her
You
tribe.
brought palm notes with you.
Yes,
Very good. Yes, what's your name?
Sthiti Pragya Sunandini.
Okay. What you want with at my hands?
Lord, arrested 3, she has given a representation for her
For a transfer.
transfer.
On what ground?
Lord, she has young kids and her in-laws are very old and
Whom you have given that representation
to
to?
collector.
Collector.
Yes.
But let the collector take a decision on that.
Lord, in place of collector, Lordship may direct the opposite part of 3, district education officer, my lord.
District education officer.
Lordship.
But at least collector should forward that representation to the district education
Right,
officer.
my lord. Lordship may direct.
Okay.
If that is pending question.
The innocuous prayer of the petitioner is for consideration of his or her
Hormel.
her representation dated 20 September 2025. a copy whereof avails at Annexure 3, wherein she has sought for her transfer from
UP school Bahadal
government UP school Prashanti Vihar
Yes, ma'am.
to
She has given 4
choice
places.
sought for transfer to one of the schools which she has enlisted in the said representation itself. First off, she has also stated certain grounds which arguably merit consideration at the hands of jurisdictional authority. First off, learned counsel Miss so-and-so vehemently argues that when such a representation is given by a public servant like her client, the same cannot be kept in a cold storage eternally. First off, she cites Article 350 of the Constitution of India in support of her contention. First off, this is appreciated. Next paragraph. Learned DSC, on request appearing for the OP, submits that it is the director of elementary education.
District
education officer.
That is OP number 3 who has to take the call in the matter, and therefore, if petitioner gives an appropriate representation to the said OP, there would be no difficulty for taking a call thereon in accordance with the transfer guidelines dated 14/5/2025 as may be applicable to the case. First off, he caveats that all contentions be kept open. First off, with this, learned counsel for the petitioner is agreeable. Rightly, first off. Next, in the above circumstances, petition is disposed of. Liberty is reserved to the petitioner to make an appropriate representation with supportive material to vouch her claim. First off, if such a representation is made, the OP number 3 shall take a call thereon within 4 weeks in accordance with law. First off, all contentions are kept open. It is open to solicit information, etc., etc. Okay, thank you.
Item 12.
Yes, Mr. Johnson.
This case is related to government of Kenya. Well, this case is related to selection of the schematic teachers, my lord. The government has not followed the release by well, government has not followed the reservation policy for not 33%, but they have gone much beyond the 33%.
But you have said 33%.
So 33% is the reservation policy. As per reservation 33%, your lordship has entertained many writ applications. I have given only one copy of the order. Your lordship,
what we have said in that?
No, only your lordship issued notice.
What thing?
I am told the number of writ applications have been filed, but I got to be able to get one order only.
Issue.
Maybe tag to that case also.
Issue emergent notice. Mr. DSC, Mr. Sen is on request accepts notice for
1 and 2.
1 and 2.
Yes,
notice to the rest. Call this matter along with WP number 22827 of 32.
This is a very factual history. This is the original writ application was filed challenging the state the selection was made on state selection basis. So that was the writ application was allowed. Writ appeal was filed. Writ appeal was single judgment was set aside. Again, they came into this district selection wise. The district selection, the mistakes have been committed as per the petitioner's case.
Okay.
Possibly.
Next.
Item 13.
Wait, please, my lord. Here, my lord, the petitioner is challenging the order under Annexure 12, my lord.
Annexure 12?
Yes, my lord.
Where is your form sheet? See, your sister had brought a form sheet. I felt so happy.
My lord.
Anyway, all right. You could have, had you brought the form sheet, you would have got another 10 marks extra. Anyway, read now.
My lord, that is Annexure 12 is under challenge, my lord.
12?
Yes, my lord. Page 50, Annexure 12. that has been issued by the incompetent authority, my lord, principal in charge of Baleswar Law College, opposite part number 4, my lord. Opposite part number 4 is the incompetent authority as the power is vested with opposite part number 3.
Yes, what do you say?
He has relieved, he is principal in charge, he has relieved the petitioner who
But you have come to court very late. Very late. Let's take notice.
My lord, the representation, my lord, I have enclosed, that is that that shall be considered by the opposite part number 3, because opposite part number has the administrative.
Number 3 is the competent authority.
Yes, my lord.
You take a call on that.
Lordship.
Petitioner is essentially laying a challenge to his discharge order dated.
My lord, dated 34 2020.
April 2025, a copy whereof awaits at Annexure 12, first stop. Learned counsel for the petitioner submits that the principal, being incompetent authority of the college, could not have discharged his client, and therefore his client has made a representation dated.
That is dated
24/7/2025, seeking a reinstatement. Wide Annexure?
Annexure 15 series, my lord.
15 series. First stop. He complains that the said representations have been kept pending without seeing a ray of light, and therefore intervention of the writ court is eminently warranted. First stop. Next paragraph. Learned ASC, Mr. Sen, on request accepting notice for the OPs, very fairly submits that if a reasonable time is granted, OP number 2 would look into OP number 3 would look into the grievance of the petitioner, as has been aired in the subject representation, should all contentions be kept open. First stop. He also agrees that it should be done in a time-bound way. First stop. This is appreciable. Next paragraph. 8 weeks. Solicit to inform.
Item 14.
Pending the rejection order, by Annexure 15 dated 14/8/2025. This Hon'Ble Court has, earlier I have moved before this Hon'Ble Court, and this Hon'Ble Court passed that by rejection order, directed the government to take a decision in the light of Honorable Apex Court. Still then they
have rejected.
You
take notice.
Yes, on the ground that the Honorable Supreme Court and High Court have dismissed the case on the ground of delay and laches.
Emergent notice, Mr. ASC, Sen, Mr. Sen ASC accepts notice for OPs. Office. Okay. Next.
Item 15.
May I please your lordship on behalf of Mr. Devendra Mishra, my lord. My lord, here the petition is claiming for
yes, sir.
My lord, the petitioner claiming for UGC scale up, there is a demonstrator of Nagar College, and this earlier he has approached this Honorable Court, and
in the light of that Apex Court confirmation of the order.
My lord.
You appear for whom, sister?
OP number 1 and 2.
OP number 1 and 2. University and the State of Orissa.
No, my lord. Union of India and University Grant Commission.
Who has to take the decision?
My lord, opposite party number 4 already rejected my claim, my lord.
Okay.
This is second round litigation. My lord, issue notice.
Madam appears for 1 and 2. AS appears for 3
and 4.
3 and 4. That's it. 3 and 4. Okay. Next.
Item 16.
Well, petitioner is a primary school teacher, my lord. He claims second RSCP of grade pay rupees 4,200, my lord. Now, similar issue has already been decided in Saraswati Bhai case, my lord. And the same has already been affirmed by the Honorable Supreme Court. And I have already ventilated my grievances, my lord, by the annexure.
The judgment is
my lord.
Saraswati
Bhai and Bath, my lord. And the same has been affirmed by the Honorable Supreme Court.
When is your representation?
Representation annexure 7.
17/4/25.
My lord.
Page 33.
Yes. Petitioner is grieving before the writ court against non-consideration of his representation dated 17/4/2025, wherein she has sought for the grant of grade pay of rupees 4,200 with effect from 1/12/2014 on completion of 20 years of service in a single cadre towards a second financial upgradation under RACP scheme in the light of benefits given to other similarly circumstanced teachers. First off, the counsel for the petitioner submits that the claim of the petitioner is supported by the OAT decision in OA number 2576 of 2016 has been affirmed by the division bench of this court in WPC 7281 of 2018 between State of Odisha versus Saraswati Bhoi 2022 to ILR Cuttack 629.
And also affirmed by the Supreme Court.
He also notifies to the court that the said decision has been affirmed by the apex court. First, next paragraph. Learned ASC on request appearing for the OPs very fairly submits that he would instruct OP number
1 minute.
OP number 1. To take the decision in the matter in terms of the representation, if all contentions are kept open and a timeline is prescribed. This is appreciable. 8 weeks.
Let's say in case 44, the state has prayed for compliance of the direction of this honorable court within a period of 3 months, and that is it. That has not been over, my lord. That time stipulation has not been over.
Anyway, you take a decision in that. Yeah.
Sub item same.
Sub item same. The representation dated. Just looking here.
Same, 17/4/2025.
Yes. Next.
Item 17.
Yes, sir.
Lord, here petitioners are praying for the approval of their post as trained graduate teachers. Their prayers are being rejected because they have secured less than 45% mark. And
you should challenge it before the tribunal, na? 24 B.
It has already been. It is a covered matter.
Covered matter.
Covered by WA 372 of 2016, which I have annexed as annexed 3.
What it says?
In page 38.
You take notice, brother.
In page 38, para 14.
Let them take notice.
Yes, ma'am.
ASC requested to ASC on request accepts notice for OP numbers 1, 2, 3.
Let's see, except 4, my lord. All opposite party except 4.
1, 2, 3, 5. Emergent notice to 4.
OP number 4.
Okay. Next.
Item 18.
18, my lord, it's covered by Ashok Mahapatra, my lord.
Ashok Mahapatra.
My lord.
Is that? Yeah, affirmed by the apex court also.
My lord.
I think it's next.
Item 19.
Lord, it is a RACP matter. So, and in this particular case, under Annexure 6, RACP was rightly compounded of 5,400. And again, by Annexure 7, the opposite party have reduced it. And also, the opposite parties have wide order
recovery also.
But the order of this Odisha Administrative Tribunal have clearly stated that in page 33, the resolutions are not applicable to the demonstrators. Learned counsel or the applicant also submit that the same resolution are also not applicant to the assistant librarians also. And the court has considered it.
Take notice. Mr. Behra, what should be done in similar matters? It's almost covered, but take notice because they may have something. This one, na? ASC send accepts notice for 1 2, emergent notice to 3.
Milord, item 22 also is also similar.
Same. Okay. Call along with same. 22 also same. Call along with each other. Yes.
Item 20.
Milord, the petition is a retired headmaster, Milord. He retired from service on 39/2002, Milord. But he was not granted the pension, Milord, except provisional pension due to pendency of the criminal case, Milord.
What happened to criminal case?
Criminal case, Milord, by the Annexure 5, Milord. He has been acquitted, Milord.
Whether any disciplinary inquiry was held against you?
No, Milord.
No discipline?
No, Milord. No, nothing is pending, Milord. After that. I have not been granted the pension and other retirement benefits.
Let them take decision. If you make a representation, then
Milord, I have already Annexure 6, Milord.
Annexure 6.
6, Milord.
In your language?
My Lord.
Dated?
Dated 9/7/2025.
Right.
To the BO, Milord.
The short grievance of the petitioner is as to non-sanctioning and releasing of regular terminal benefits, including the pension, on the ground that he was involved in a criminal case. What is that case number?
Case number 266 of 993.
What is that case name?
GR case number.
GR case number 266
of 1993.
1993, punishable under sections 420, 468, 471, read with 120B, and section 34 of erstwhile IPC 1860. Counsel for the petitioner submits that he has secured acquittal in the said matter. Why the order dated?
Let's say he has been discharged.
Let's say under 2780. Discharge, secured discharge 239.
239, my lord.
Discharge under section 239 of CRPC.
On
Why the order dated
29/5/2025.
29/5/2025 at the hands of which court?
The JMFC.
The JMFC is fine. So, first, he also tells the court that though all this is brought to the notice of the jurisdictional authorities by representation dated 9/7/2025, nothing has been done in the matter, and therefore the interference of this court is eminently warranted. Next paragraph. Learned ASC, on request accepting notice for the OPs, very fairly agrees to instruct the jurisdictional official to look into the grievance of the petitioner, as has been aired in the subject representation dated 9/7/2025, if all contentions are kept open and a timeline is prescribed. First off, this is appreciable. He also tells the court that the petitioner should cooperate in producing all required material for easing out decision making. First off. Next paragraph. In the above circumstances, petition is disposed of 6 weeks. Solicit. Next.
Item 21.
May please, Your Lordship. But the petitioner has retired from his service.
Contentions kept open. Yeah.
My lord, the petitioner has retired from his service on 31st of May 2025, my lord. My lord, and there is no criminal and departmental proceedings pending against him. But as per the provisions of the pension rule, my lord, Rule 62, and as well as the instructions issued by the government, the pension papers, the pensions to be finalized on the date of retirement of the government officer, my lord. Your lordship may kindly come to.
That they have not done.
They have not done, my lord. Despite there is no pendency of criminal and departmental proceeding.
Nothing. But they don't want to settle your pension papers.
Pension papers, my head of office has already submitted the pension papers before the pension sanctioning authority prior to my retirement. Despite that, my lord, it has not been sanctioned till date, my lord.
When you retired?
My lord, 31st May 2025.
31/5.
It has to be, my lord. As per government guidelines, you also may kindly come to page 24.
Yes. Take a decision in the matter. Petitioner is grieving against non-sanctioning and releasing of the regular terminal benefits, including the petitioner, including the pension. Though he retired on attaining the stage of superannuation on 31/5/2025. First of all. The apex court in Padmanabhan Nair versus state of so and so, which is that judgment?
State of Kerala.
State of Kerala.
Pension.
Interest to urgency of deciding the pension matters, etc. It was decided in 1983, but reported later. That's what you told you about 1 month back to me. Can anybody take out that judgment? So and so has held that Padmanabhan Nair, state of Kerala versus M. Padmanabhan Nair. Bible.
1985, AR 356.
AR 1985, SC 356.
Yes.
Has held
State of
that.
Kerala versus
Yes.
the M. Padmanabhan Nair decided on 17 December 1980.
That you are right. Has observed that pension, not being a bounty, has to be sanctioned and released to the retiree without broking any delay. And if delay is broken, interest needs to be paid. First of all, counsel for the petitioner submits that there is no civil or criminal or departmental case pending against his client. Right? And despite that, the pension is not being sanctioned and released. And therefore, the intervention of this court is warranted. First of all. Next paragraph. Where is your representation?
Lord's representation, my lord, is at page 27, annex 20.
Learned AGA, the ASC Mr. Sen, appearing for the OPs, very fairly submits that the petitioner has already given a representation dated 19/5/2025.
And thereafter 2/6/2025.
And 25 at an value series. And therefore, he would instruct his officials to look into the grievance of the petitioner on a war footing, keeping in view the Padmanabhan Nair Supra and other norms, if all contentions are kept open. First off, he also requests the court to give a reasonable time for making a decision in the matter, which would include a host of factors. First off, with this proposal, counsel for the petitioner is agreeable. Next paragraph. 6 weeks. 6 weeks. Delay shall carry interest at the rate of 1% per annum, per mensum, which may be recovered from the hearing officials. Structure it that way. Yes.
Item
Next.
22 has been adjourned. Item 23.
May I please, ma'am?
Yes, brother.
Dear petitioner was appointed a contract Hindi teacher on 4/4/2016, my lord. As per the provision, my lord, he is to be made regularized after completion of 6 years. Before completion of 6 years, my lord, because of some dispute in their village, a criminal case was instituted against the petitioner, and petitioner was arrested on 23rd of December 2021, my lord. I was engaged on 4/4/16. I was arrested on 23rd of December 2021. And on 14th of March 2022, an order was passed by district education officer indicating that in that petitioner is hereby deemed to have been temporarily disengaged from the contractual engagement with effect from the date he detention in the jail custody, that is from 23rd of December 2021.
When you were released from
I released on bail on 27th of December 2021.
What he says?
He said that from the date I was arrested on 23rd of December 2021, petitioner is deemed to have been disengaged, though there is no provision in the system.
Deemed to have been?
My lord?
Deemed to have been?
Disengaged from the service, my lord.
Descended.
My lord, though there is no provision, this is
Descended means what?
disengaged.
Disengaged.
Disengagement. Disengaged.
Okay.
Though there is no such.
He was convicted, my lords. Conviction is there.
Conviction is there.
That is subsequently, my 23rd of October 2023.
Yes.
My submission, my lord, on the date order was passed on the as per the Odisha CCA rule 1962, there is no such provision like deeming disengagement of an employee, my lord. Rule 12(2) says if a person is
suspended,
deemed suspension provision is there. If and a judgment also is there by coordinate bench. A deemed suspension provision is there. They cannot pass order for deeming disengagement. So I was, by that time I was not convicted. Convicted was after 1.5 years after, man. So that order, I challenged this order before the Hon'Ble Court. This Hon'Ble Court directed you go and approach the authority with the representation.
No, what conviction? What happened to conviction?
Conviction, I have challenged, my lord, an appeal that is pending.
The appeal is confirmed. Revision is.
This Hon'Ble Court is pending.
1 year conviction.
1 year conviction. So, what is your grievance?
My grievance, my lord, that since there is no provision of deeming suspension, petitioner, because there is a rule 18 provision is also there. If petitioner could have been suspended by taking the aid of deeming provision, the petitioner could have continued there, and rule 18 provides, notwithstanding anything prescribed in rule 15, 16, 17, a person can be disengaged by taking approval of the commission if he was found convicted. That's recourses they have also not taken.
But you mean to say you are not removed at all now?
No, on that date, that is 13.
That's all right. There is conviction.
Well, now conviction, they have to pass an order by taking aid of rule 18.
That is only direct. The Supreme Court has said it is such a rule is directory.
An order is to be passed, my lord.
Supreme Court has said in Karnataka matter, such a rule is directory. Even if no such permit sanction is taken, still you are out of service.
Appeal is also pending.
Therefore, let appeal be decided.
That if this order is to be,
you approach court after the decision in you are a convict now.
Annex 4 can you see the deeming disengagement. This order I can be taken as a disengagement employee from the date of conviction at least, not from the
date of conviction. But now you are convicted. No relief can be granted to you till that conviction is set aside.
Till the date of conviction. Till the date of conviction, order was passed by the court below. Court below. I petitioner, till the date of my only submission. Till
understood. You have said it number 3-4 times, sir.
Sorry,
I also said it 3-4 times.
Sorry.
The question is, you raise all these contentions after you succeed in your revision petition. Appeal.
Appeal is confirmed.
My appeal has been dismissed.
You are convicted, appeal is dismissed, revision is pending. After the revision order, these contentions are available to you. Not at this stage. No writ court shall pass order of non-utility. That is the law. Your Justice B.L. Hansaria, when he was here, he wrote that book, na? Jurisdiction published by Indian Law Institute. Therefore, I want to dismiss this petition, or you want to withdraw with liberty to approach the court depending upon the outcome of the revision petition. I leave it to you.
My lord, I may be given liberty to approach after the disposal of the revision.
Petitioner has approached the court with the following prayer. Now, I will say, may not withdraw because your client may not agree. Approach the court with following prayer. First off, learned counsel for the petitioner submits, when his client was under detention during the period between 23/1/2021 and 27/12/2020, 23/12/2021
arrested
and 27/12/2022, comma. He was under suspension. He was under deemed suspension by operation of law, and therefore the said period cannot be treated as disengagement at all. First off, he also fairly mentions about his client having been convicted for in a criminal case, and his appeal having been turned down, a revision petition is pending under section 397 of CRPC, correct? Before this court. Before this court. First stop. Next paragraph. Learned AGA Mr. Behura at one point appearing for the OPs at once points out that since the petitioner has been convicted and sentenced, the question of considering his prayer of the kind would not arise. First off, he also tells the court that petitioner can seek the appropriate relief after he succeeds in the revision petition by gaining acquittal. Gaining acquittal. First off, there is force in this submission. Next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to approach this court, depending upon the outcome of the criminal revision petition number
55 of 2025.
25, pending on the file of this court. Okay. Pending on the file of coordinate bench of this court. Okay. Item 10? Yes. Yes, sister. What do you want? Pass over.
No, sir. No, you have given me the time.
Your Lordships, I'll press the matter. Your Lordship permits.
And what I did in that 7, 8, 9 is pass over. You are prepared now.
Yes, Your Lordship.
Yes, what is your matter?
Lordships, this matter pertains to the rejection of a certificate pertaining to income and asset in favor of the petitioner, which has been rejected by OP number 2 Tahsildar. And the sole ground of rejection of my application is the reports of RI basing on excess Gharbadi, which is at Annexure 4, page 20, Your Lordships. Your Lordships, the excess Gharbadi, which has been taken as a ground, it is the combined land property and it belongs to the recorded in the name of grandmother. And grandmother is not a member of the family as per the definition of a order.
Family definition is given.
Yes, Your Lordships.
Mother is not one of them.
Yes, Your Lordships. I have annexed it in Annexure 3, Your Lordships, para 4th para.
Okay. It requires consideration. The term family for the purpose which will include the person who seeks benefit of reservation. These are her parents, siblings below the age of 18 years. But not the grandmother.
Not the grandparents.
You're right. You have made out a case. Heard, learned counsel Srimati so and so, so and so. The case is made out by vehement submission, by drawing attention of the court to the legal position. First off, issue emergent notice. Mr. Lenka is requested to accept notice for 1 and 2. First off, matter lies in a narrow compass. All the same in the second week of January 2026. Okay. You argued very well.
Grateful, Your Lordships. Grateful.
Legal points. Yes.
Item 24.
Your Lordship encouraged her that he should sit in the courtroom and
they will do. Otherwise, they come. Defect lies with the judges, not liars. It lies with the judges. If we threaten you, if you discourage you, how you will argue?
Yes.
We should hear all your points first, patiently. At least first three minutes, they should be given free flow, so that whatever they want to say, we can hear. Then we can put questions. And tomorrow, these are the judges who will protect us. Therefore, there is a duty to upgrade the bar. That's the reason why I engage so much in the discussion with all of you. You will be knowing the rulings. You may be smiling at your heart saying that why this judge is asking this question. Not for you. It is for many youngsters who sit in the court hall. They get some inspiration. They will go choose some book and go and read that way. Okay, thank you. Got it. Tell your experience to your friends so that they also will be encouraged.
Item 24.
May I please, Your Lord?
Yeah.
Well, in this case, Lord, the petitioner was appointed as a resource person with a consolidated remuneration of rupees 4,000 on contractual basis against a regular vacancy, Lord. In the year 1998, in a regular process of selection, advertisement was issued, Lord, selection was conducted, and but they have given appointment on contractual basis till the post is regularly filled up. Thereafter, my lord, my service was regularized, my lord. On 2013, on 31/10/2013, my lord.
What happened?
My case is that, my lord, now I pray, my lord, Lord, that period, my lord, contractual period may be counted for pension, my lord. And in coordinate bench, my lord, in
Annexure 7 is pending, my lord.
Let them take Annexure 7 in the light of
page 49.
The short grievance of the petitioner is against the long pendency of his representation dated 18/12/2024 at Annexure 7, wherein he has sought for counting the contractual period for grant of pension in terms of Orissa Civil Services Pension Rules 1992, and in the light of which is that decision?
Dilip Kumar Panda versus State of Odisha.
You have said something.
Judgment dated 6/9/2024, page 49.
Give that citation.
I have already annexed, my lord.
Page 49 it is there.
In terms of the decision of division bench of this court at court in page 49. Okay? Right. First, counsel also tells that this decision has been affirmed by the Supreme Court.
Not affirmed.
No, not affirmed. The learned counsel submits that if a decision is taken on the subject representation in a war footing, his client would be satisfied. First off, with this proposal, learned counsel appearing for the OPs is also agreeable, subject to the caveat that all contention should be kept open and a reasonable timeline be prescribed. First off, next one, 8 weeks. Next.
Item 25.
Well, this matter relates to entry dating of lecturer group A scale and reader state scale. But the petitioner has made a representation to the opposite party number 1 under Annexure 6
right now. Petitioner has made a representation dated 12/8/2025 at Annexure 6 to the Commissioner cum Secretary to the Government in Higher Education Department.
Yes.
First half. In the in the said representation, he has requested to antedate
lecturer group A scale.
Lecturer group A scale of pay with effect from 1/7/1997
instead of
2/7/2001,
and reader state scale.
Reader's state scale with effect from 1/7/2007
instead of 2/7/2011.
Basing upon Rule 41B of Odisha Non-Government Aided College
Lecturers Placement Rules 2014.
Prior text. Okay. Counsel for the petitioner submits that if a direction is issued to consider the subject representation, any decision is there.
Well,
in the normative process,
that is the law.
Satisfied.
That is in accordance with the rules.
Learned DGA Mr. Behura on request appearing.
My lord, 7 years after he has approached, delay and laches.
And other things I'll keep 182 opposes the petition contending that there is lot of delay and latches on the part of the petitioner and therefore no relief can be granted. Person. Having so contended, now he fairly submits that he would instruct OP number 1 to look into the grievance of the petitioner as has been aired in the subject representation in accordance with law, if all contentions are kept open and also a timeline is prescribed. First, with this proposal, counsel for the petitioner is agreeable. What is it? 8 weeks. Open to solicit, etc., etc. Next.
Item 26.
26 block grant pension matter, similar to item 4. Today's you also already issued notice in similar matter.
Issue emergent notice, all along with serial number 4.
No.
IT accepts notice for office. Controller of accounts also you want?
Yes.
Okay. Next.
Item 27.
Well, this is a case of transfer. Here, my lord, I have challenged the order of transfer on 3 grounds.
My lord, similar case, your lordship directed to consider because it is past 40 days before.
Yes,
lordship.
yes, I am conscious of that. But the order was passed on 23/10/2025. But I have taken 3 grounds. My first ground is I have not completed the normal tenure of 6 years. I have only completed 2 years and 3 months in my previous place. My second ground is this transfer has been made on the basis of, on the guidelines of, on the basis of rationalization principle. But there are 92 students, that is a upper primary school. Including the petitioner, there are only 3 teachers. It fulfills the criteria of rationalization. So there is no justification to transfer me on the ground of rationalization. And the third ground is, my lord,
you file appeal.
Yes, your lordship.
Petitioner is calling in question the transfer order dated 23/10/2025, a copy whereof avails at Annexure 2.
Yes.
First. Learned counsel for the petitioner urges certain grounds for invalidation of the said order. First. Learned AGA Mr. Behura, request accepting notice for the OPs, very fairly submits that there is a departmental appeal provided under the transfer guidelines dated 14/5/2025, and therefore the writ court should not come to the aid of petitioner, and instead he should be relegated to avail the said appeal. First off, with this proposal, counsel for the petitioner is also agreeable, provided that his client is protected for a reasonable period, so that he can present the appeal and seek relief at the hands of appellate authority. First off, this is fair. Next paragraph. In the above circumstances, petition is disposed of. Petitioner is granted a period of 10 days to prefer the departmental appeal on merits.
Before OP number 2.
Before OP number 2. First off, till the appeal is considered, heard and decided, petitioner shall continue in the same school, provided unless he has been already relieved. This way, already relieved. First off, in the event he is relieved, he shall report duty at the transferred place forthwith as a precondition for considering the appeal. Yes.
Item 20.
Item 28, that MP MLA transfer. Yesterday's
MLA transfer. Yes, issue notice. AG is requested to accept notice for. Can we have it tomorrow?
Yes.
Tomorrow on this matter. Day after.
Yeah.
Yes.
Item 29. Item 29.
But in this matter. Take notice, Mr. Behura. The notional date he wants. Behura is requested to accept notice for one box.
Item 30.
Yes. But this is a case of transfer. But here within the span of 4 years, I have been transferred for 4 times. But my father is ailing.
Here also you can, even that can be a ground in departmental appeal.
No, you are saying kindly see. Here my prayer is different. But I have made a representation to the district education officer Devgarh. I am a state cadet teacher. I am serving in a high school. I requested for my transfer to from Devgarh district to Baleswar district. And that recommendation is there. Your Lordship may kindly turn to Annexure 8 at page 57.
Recommended for?
Recommended for my transfer.
By whom?
By the director to the Baleswar district. This letter has been addressed to the director secondary education.
No, that is not acted upon.
That has not been acted upon, and I have made a representation under Annexure
11/20.
Annexure 9.
Annexure 8 of year 2020-22.
That has not been acted upon. But my recommendation is there since
2022.
But now you make a fresh representation.
Well, I have made a fresh representation.
Annexure 9 is
Annexure
pending.
9 is pending.
Then you can say
Yes.
that. Petitioner's grievance is non-consideration of his representation dated 12/11/2025, a copy whereof avails at Annexure 9, wherein he has sought for cancellation of his transfer order dated 10/11/2025, issued by the District Education Officer Devgar, whereby he has been deployed to Government High School Kalla.
Yes.
Kalla.
And I have also prayed for my transfer from Devgar.
So you are transferred from which place to which place now?
Well, that is Kalla.
You seek transfer to that.
No.
Or you are
Well, I am
transferred?
challenging that.
Kalla.
Kalla. But my main ground is that I seek transfer from Devgar district to Baleswar district on the ground of illness of my father.
He also seeks a direction for posting him from Devgar district to
Baleswar district.
Baleswar district.
In any
school in Baleswar district.
In any school.
On certain ground, more particularly the aged parents ailing.
Yes.
Ailing. First off. Learned counsel for the petitioner submits that if a direction is issued for its consideration in a normative way and on a war footing, that would do justice to his client. First off. Next paragraph. Learned AGA appearing for the OPs is very fairly agreeable to the proposal of the petitioner, provided that all contentions are kept open. First off. You add that sentence to that. The above circumstances. Within 3 weeks, you should consider that.
Your Lordship,
3 weeks, 4 weeks. Within 4
Your Lordship, kindly add only one line. Taking into account the district education officer's recommendation dated 21.
Considering, the recommendation of district education officer dated
21/5/2022 under Annexure 8.
21/5/2022 may also be looked into.
Yes.
Also be looked into, whatever be its worth because of lapse of time.
Yes.
Item 31.
Then open to solicitation.
Well, Your Lordship, kindly see the last order.
31, my lords.
36/2025.
Yes, my lords. I have not got any instruction. Your lordship may call after 2 weeks. This is.
My lord, I succeeded in the tribunal.
Yes, I don't
The
dispute.
judgment was upheld by this honorable court. They went to the honorable apex court. Apex court also dismissed their SLP. Thereafter, they are not implementing the order.
For implementation, execution case is to be filed. I am not there, but
On 13/6/2025, Your Lordship directed the State Council to take instruction in the matter.
time may be granted, my lord. 2 weeks I will take instruction. But
Finally, 2 weeks. At the request of learned AGA. First off, non-compliance within the said period will be waived very seriously. And the cost in thousands of rupees may be levied on the lapsing officials. First. Next.
Item 32.
Millard, here notice had gone.
Yes.
Appeal notice had gone on respondent number 1C to 1E. And now it appears that so far as D is concerned, I have to take press steps because notice has gone on.
No such addressing.
Yes.
So
I have to take steps.
Press steps.
My learned friend says he has got instruction to appear for all.
I have an instruction to appear for all.
So notice may not be necessary.
Yes. Office indicates the requirement of taking fresh notice in respect of respondent number 1D.
Yes.
On the basis of postal chara. First off. Learned counsel Sri
SS
Parida, who appears for
Tanmay Mishra associates.
for him alone.
But for all. One
Who appears for the rest of the respondents also appears for this respondent. First off. Therefore, the office requirement fails into insignificance.
Millard, here,
yes,
I have filed an application for stay of the further proceeding in the execution proceeding.
Who argue or RSA?
The only dwelling house wherein I am residing with my family.
You argue the main matter. I am ready. 2007 matter it is.
Hon'Ble?
It is 2007 matter.
Yes, now
I am ready in the matter.
Now position will be delivered.
You argue
stay is
now.
granted.
You argue now.
I will be out of Ajib. I will be thrown out of my dwelling house.
No, if you succeed today, nothing will happen. Today you argue this matter, 2007 matter.
Then a date may be fixed.
Copy of the IA has not been.
A date may be fixed for hearing.
Tomorrow?
May not be required because if your lordship is
2007.
Yes, inclined to hear the matter on merit.
To hear RSA.
Yes. Your lordship fix a date. Because
whichever date you want, but no interim will be granted. If you are ready, argue the matter. Otherwise, take a date. That day you argue the matter.
Yes.
Take that, whichever date you want.
Any date in December
you pull down from the calendar.
23rd?
23rd. All right. Call this matter, they call this very old matter on 23/12/2025 as requested by both the sides.
18th or 17th?
18th or 17th? Is it agreeable to you, sir? He says 18th or 17th.
That's the previous week any date?
17. How many matters have been posted on 17? What is it, a concurrent finding or divergent finding?
Reversing.
Reversing. Divergent. Okay.
18, sir.
Latest judgment has come in 2025 on divergent proceedings, the approach of the court in second appeal. Kindly look into it, come back. It will be in your favor. On maintainability and other things. Just look into, glance that. Yes.
Item 33.
100 appeal it is. 100 appeal. Yes. I'll come back within a few minutes. Yes.
Item 32, my lord. The LCR has not come, my lord.
LCR.
My lord.
Registry to secure the LCR with lightning speed. And failure may result into initiation of disciplinary proceedings. Yes.
May I please, my lord? Very deep, yes, my lord. Petitioner of the teacher after superannuation 2020 in May 2021. The proposal submitted by the BEO for religion pension, my lord. Page Annex 4, page 18.
You retired on?
31st May 2021, my lord.
31 May 21.
My lord. Annex 4. Provisional pension is granted thereafter. In April 5th, April 22, the proposal submitted by the BEO to control account for final payment. At this juncture, Annex 5 is issued by the control accounts, raising some objection. And without issuing a notice to me, while releasing my gratuity, my pension benefits under Annex 6, that are reduced and an amount of rupees more than 1 lakh directly to recover. I approach my issue notice. In this counter, they have issued an annexed letter by the BEO. That is, my lord, under Annex 6, and that is Annex 7 to my miss case, 5/2024. That my pay has been reduced, but no notice to me. Therefore, I filed a petition amendment challenging to that order, my lord.
We'll allow this, Mr. G. We'll allow this application. Let him file the amended petition. File your objection.
Yes, I think.
Application seeks leave of the court to amend the petition for laying a challenge to the letter dated 20 February 2023.
5/4, my lord. 5/4/23, my lord.
5/4/23.
My lord.
5/4/2023. Issued by
the BEO, OP number.
Issued by the DEO.
To BEO to the control accounts.
Controller of accounts. Accounts. First off, the contents of the letter in question have something to do with the relief sought for in the petition. First off, there is contiguity in terms of cause of action and the relief sought for. First off, if leave is accorded, no prejudice will be caused to the other side, who is a pensioner, who is a retired employee. First off, on the contrary, if leave is denied, is likely to be put to prejudice. First off. Next off, in the above circumstances, application having been favored, leave is accorded and petition to be amended within 2 weeks, and amended petition to be filed within 3 weeks after serving a copy thereof on the other side. First off, other side, which may file its counter within next 2 weeks. First. Yes.
Item 34.
Yeah.
Passover.
Passover.
I have some personal difficulty.
Some other day we'll have that.
But I have difficulty, because we are ready.
What is so much urgency?
But the urgency is that the land in question has been already allotted to me.
If you're not
I have sanction, loan has been sanctioned and woods has been loaded, my lord.
Now what happened?
My lord, now the stay is operating.
Stay to?
Stay not to carry out.
What is the interim order?
Internal status quo.
Status quo in respect
Status
of
quo.
the
Yeah,
land.
you are enjoying. Whoever is in possession. Status quo. Whoever is in possession is enjoying.
My lord, in my possession.
No problem.
He cannot proceed with the, my lord.
Construction.
Yes, my lord. That may be observation, maybe otherwise they won't allow.
He is not eligible. For that reason, my lord, last occasion your lordship directed me to file the certified copy of the orders on which, my lord, he has got land in the industrial estate, which is earmarked for the persons who have, my lord, whose sawmill have been closed down by virtue of the orders of the Supreme Court.
Correct, but
he is not, my lord, in that category.
No,
but
your friend is saying Passover.
Yes, my lord.
Even Passover also?
Yes, my lord. Yes, my lord. That will Passover.
Passover, my lord, because I have some difficulty, my lord, 7 courts, my lord, matter have been listed today.
No, I don't.
I am adjusting in all the courts, my lord.
That is.
You are a very busy lawyer, is known to me.
No, my lord, that is not correct. Today, my lord, today I have been in difficulty.
Yeah, what time you will be free?
Pardon, my lord?
What time you will be free today? You tell, I will call this matter at that time.
My lord, one matter is 97 in one court. It will be reached at 4, after 4, my lord.
My lord, may I? If I can be accommodated. My lord, urgent, otherwise I won't submit.
In all matters, Dixit's court is very urgent. I know that.
because my lord, favorable orders we are getting.
Orders according to law.
That's
orders according to law.
Yes,
My lord, I also pray for equity. Whatever.
You also want time?
No. When your lordship is granting them relief, we are also planning
relief to you also wherever we are going this.
No, my lord, they are forgetting that the laws are framed.
The thing is,
laws are framed for the citizens, not for the government. And the laws.
No, he is praising you.
No, he is claiming equity.
Anyway, we'll have this matter. Since how long it has been there? It has been 2025 matter.
2025
matter. We will have this matter in the second week of January 2026.
My lord, please, my lord.
Nothing will happen.
Difficult for me, my lord.
There are many matters. For everybody, there is difficulty.
Lord, I bow down, my lord. My lord, the difficulty is that, my lord, tomorrow or day after tomorrow, my lord.
No, I cannot be so much stressed like that. And you have to ensure that judge does not die.
No, my lord, that.
The council also not ensure that the council
will not die, my lord. My lord, just December, my lord. My lord, I prayed December.
This we have difficulty. Otherwise, I would have a question. Yes.
My lord, interim order में kindly.
Item 35.
Yes. What status? What improvement you want to do in the land?
My lord, I have to install. Just a minute. I have to set up an industry, and already execution deed of execution agreement has been executed.
When?
My lord, that was 25.
2025.
Yes, my lord. My lord, the thing is that I have already sanctioned, loan has been sanctioned, about 2 crores, my lord. And I am losing the interest day by day. And
no, by sanctioning loan, interest will not accrue. When you release it, interest accrues.
My lord, that
is the RBI guide.
My lord, yes, my lord, but that I cannot operate now because of the stay order. And
That you cannot operate, but no interest and the other things are accruing to you because amount is not released from the account.
My lord, the problem is that goods already been exported, my lord, and nowhere to start in it.
The second week of, in the first week of January 2026.
And the interim order kindly be
Date may be fixed.
Yeah.
Date may be fixed.
First week itself. Yeah.
Item 35.
Your Lordship may kindly see the order dated 29/10/2025.
Lordship may kindly call this matter tomorrow or day after tomorrow.
Yeah.
I will.
Interim order to continue.
Interim order.
Item 36.
Withdrawn liberty. Withdrawn. I have Thailand.
With liberty. With liberty. Yes.
Item 37.
May I please, Your Lordship?
Yes.
The order under Annex 10, Your Lordship, page 44 is under challenge. But the collector passed the order without complying the direction issued by this Hon'Ble Court in division bench. The Annex 8 is the order, Your Lordship, passed by this Hon'Ble Court. Complying that order, Your Lordship, the collector has to decide the appeal. Matter relating to cancellation of residence certificate, Your Lordship.
Residence certificate.
My lords. The
allotment letter cancellation, or you should not reside here at all. What is meant by residence certificate?
Residence certificate to get job, Your Lordship, to as a proof of residence to a certain area. Yes, Your Lordship.
Where is that certificate? Just show me.
Annex 1, Your Lordship. My lords. Page 16, Your Lordship. Annex 1, page 16, Your Lordship.
Client is calling to argue the matter well.
No, my telephone was sorry.
Read it.
Page 16, Annex 1.
It's a pure residential certificate.
My lord.
That has been cancelled.
Yes, Your Lordship.
Who cancelled?
The sub-collector, Your Lordship.
Sub-collector.
My lord.
Why he cancelled it?
Yes, I'm coming, Your Lordship. That file a death charge, Your Lordship.
But all that is not
yes.
possible. What is the ground of cancellation? We are in rich jurisdiction, not the RFA, RSA. Yes.
In fact, there is no ground for cancellation, but authority compelled to cancel it on the ground that in 2000, Your Lordship.
Where is the cancellation order?
Cancellation order, Your Lordship, it is that is Annex 6, Your Lordship, page 26.
26. Go to 26.
Page 27 for an order, Your Lordship. The peruse the report, page 27, Your Lordship.
Report of Tahsildar.
Contamal Tahsildar, where his the opinion that the residence certificate issued in favor of the Jiten Satyad petitioner should be cancelled.
Why?
On the reason is not there, Your Lordship.
No, below read it.
Yes. The Tahsildar Contamal is the case record with a direction to cancel the Jitendra Chhat's residence certificate, which working as a GRS in that Khatia GP, given opportunity of a hearing for a
For a formal
and conformal also.
for order of rejection of
Residence certificate, the letter number so and so.
Why it is cancelled, Mr. Lenkai?
Cancelled because he is having residence in other place.
Means what?
I'm coming, Your Lordship.
1 second.
Your Lordship,
Several such matters. Just yes. They will cancel. To whom it is issued?
Today again, in favor of the petitioner.
No. In the norms, in the rules, to whom you will issue it? Who is residing in a particular place? Correct?
Yes.
How are you going to decide he is residing in a particular place?
That will be
Ration card, voters list, payment to KB bill, electricity bill, etc.
Yes.
A membership of cooperative society, or membership, such other documents.
Yes, sir. Last time you were also directed to produce the record.
Yes.
I brought-
Simple things I am saying.
Yes.
He is reading that order, which does not has a head and tail. The Tahsildar said and it is rejected. What is this?
No, thereafter,
On what ground it is happening?
thereafter that order was challenged before this honorable court.
Which are the rules which regulate issuance of certificate?
The Orissa Miscellaneous Certificate Rule 1984 LRC.
1980. Can we have a copy of that?
Yes, LRC. Yes, sir.
Please pass on. He should be ordinary resident of that area.
Yes, LRC. The people
Residents for nativity certificate. What is the basis for that? Gazetted doctor on the basis of his personal knowledge, not covered under the provisions of Schedule B, Schedule H, shall be granted in accordance with provisions of those cast and the request of the instructions that we can govern the substitution shall not be granted. Even the certificate shall be granted for limited purpose of the travel of pension, gratuity, arrears, salary, etc. Income accrued from remote purposes situation within the area in which the revenue currently issued. The income from movable property, the income from trade or business, the income from salary, wage, remuneration, to whatever form received from government, third, PSU or private, and the like shall be taken into account while granting income certificates. In case of salary person, the revenue officer below the revenue that shall be granted of always. In other miscellaneous that in some countries where we are concerned with the yes, what is so very badly drafted. Yes, next. So far, what are the guidelines for issuance of residence certificate, nativity certificate? Take the rule and read. All those which you have mentioned, they do not relate to as the grounds for issuance of nativity certificate. They relate to other certificates in that. About nativity certificate, who should issue? At the most, officer can issue. On what basis? Income certificate is there, other certificates are there. Take out Supreme Court judgment. Manmohan Singh versus so and so. Election law. Dr. Manmohan Singh versus so and so. See, the nativity certificate has to be issued on the basis of the norms evolved by the Supreme Court under Section 20 of the Representation of People Act. Because you are not prescribed the norm at all. This is the Election Commission of India versus Dr. Manmohan Singh. This is the judgment. Question arose before the Supreme Court whether Dr. Manmohan Singh, the former Prime Minister, was a resident of West Bengal or not.
Assam.
West Bengal. In that case, na?
Assam.
Assam.
Because he was repenting from Assam to Rajasthan.
Maybe right, I may be wrong. Anyway, that question arose. There the Supreme Court discussed how to decide whether a person is an ordinary resident of that particular area. On that basis, we have to decide this matter. Because no norms are given to decide whether you are a resident of that. You may have one house in Cuttack, another house in Palesar, yet another in Bhubaneswar. Then question will arise, which place resident he is? How are you going to do that? There is indication. Look into that judgment and come back. All right? Call this matter in the second week of January 2026. Yes.
Item 38.
May I please? The matter relates to issuance of DLD certificate.
Which certificate?
DELED certificate. Diploma in Elementary Education certificate. By the opposite parties, that is National School of Open Schooling. My lord,
it is issued to whom?
My lord, I have prayed for issuance of that certificate to the petitioner.
Petitioner. Under which rules?
My lord, as per their notification.
Show that. Which is that notification? And the notification is issued under which act?
My lord, that is under RT Act.
RT Act.
RT Act. Your lordship may kindly see their counter. I have passed that examination, but they are not issuing that certificate.
Now let us see the rules now.
Yes.
Which
Your
governs
lordship may
issuance of the certificate.
Yes. Your lordship may kindly see their counter. Annexure A.
Any rules are produced?
Annexure A at page 11. Their counter. That is the.
So where are the rules which govern this?
Well, at this letter, this has been issued by the Government of India, Ministry of Human Resource Development, Department of School and Education Literacy, basing upon Section 23(2) of the RT Act. And this is regarding training of untrained in-service elementary teachers in the government-aided, unaided private schools. It is apprised that the amendment to this Section 23(2) of RT Act.
That are not valid. Which is the provision which relates to your issue?
Issue is, your lordship may kindly come to page 12, Roman 14.
Page 12 or 20?
Page 12 of their counter.
Internal page 12.
Internal page 12 of their counter.
Continuous page 27.
Continuous page 27.
Teachers who do not fulfill the minimum.
Teachers who do not fulfill the minimum eligibility requirement, but taking admission in DLED program, that is 50% in class 12, will have to join NIOS
and
reappear for the class 12 examination to achieve the minimum qualification. They would, however, be eligible for provisional admission to DLED program of NIOS subject to them acquiring 50% marks in class 12 before completing the DLED program of NIOS. This would facilitate such teachers to pursue the programs concurrently. Here, my lord, the petitioner took admission in +2 course as well as the DLED program at the same time, and he passed +2 examination
before completing the program.
Yes, he passed +2 examination initially on 6/6/2019 with 53% of marks. Requirement is 50.
Where is that 50?
50 is, yes. Now, your lordship may kindly come to the rejoinder, my rejoinder.
Now, why they say that you are not entitled to?
They say, well, they are not saying that I am not entitled. Yes, my learned friend is appearing.
Why do you say you are not entitled to?
Well, their stand is.
It's a case where he has been gets passed, but the certificate has not been issued, not certified, NC. It has been marked NC. The reason being that at the time of taking admission to the DLED course, as required under the guidelines, he had mentioned class 12 percentage as 0. That means to say that he had never passed the minimum plus class 12, and the minimum criteria for eligibility to take admission into this course was 50% marks.
Anyway, now he has
that he has done. But question is, your lordship, that particular notification, that letter of the Government of India, which Human Resource Development, School Education Literacy, which my learned senior was showing, your lordship may kindly turn to page 11 of my counter. In that particular letter, first page. Annexure A.
The same guidelines
which guideline which my learned senior was showing. This is regarding training untrained in-service elementary teachers in the government aided unaided private schools. It is apprised that the amendment to the section 32 RT to extend the period of such training to 31st March 2019 has been passed by the Parliament. So thereafter, further it is related that this will be the last chance to acquire requisite qualification. Any teacher in the aforesaid schools who does not have minimum qualification mandated would not be allowed to continue. Here, the time frame was 31st 2019. 31st March 2019, and here in the present case, he has cleared
6/6/2019.
Yes, my lords. He has cleared that in April 2019. Thus, he has been marked as NC. So that was admitted, means not certified.
What do you say about the cutoff dates?
Yes. Your lordship may kindly see their counter itself.
No, let us see the policy itself.
Yes.
Whatever be the counter.
My lord.
You adhere to the policy.
Yes.
Annexure A.
Annexure A.
Yes. 3 August 2017.
Yes.
Describes 31/3/2019.
Yes.
As the cutoff date.
As the cutoff date.
Yes.
As the cutoff date. My lord, I passed.
Let us see what it says. Para 3.
Para 3. Yes.
A broad strategy to complete the training of all such in-service
untrained teachers by 31st March 2019 is proposed by MHRD. The following action is required to be initiated urgently at your end.
Yeah.
My lord, now your lordship may kindly come to Roman 14, which comes to my rescue. Because initially, when I applied, my lord,
you passed it on 6/6/2019. Second
+2 examination.
He's on 6/6/2019.
+2 examination. I passed on 6/6/2019.
Then it falls outside the cutoff date.
My lord, now your lordship may kindly see. My lord, I have fulfilled the requirements so far as clause 14 is concerned.
Clause 14 is subject to main clause 2.
Yes, clause 2 is the last date that is for strategy. Strategy to complete the training of all such
Training itself should be complete before this date.
31st March 2019.
Correct.
I took admission before 31st March 2019.
31st March 2019. When did you take the admission?
Yes. Your Lordship may kindly see.
No, course should itself be completed before 31/3/2000.
No, my
Yes.
Yes. It only says
the broad strategy to
complete the training of all such instances and trained teachers
31/3
by 31st March 2019. My Lord, I took admission prior to that cut-off date. That is 31st. My Lord, I have given a date chart. Your Lordship may kindly see. I have given a date chart. On 14/9/2017, the block education officer granted permission to me to take admission in +2 as well as DLED program. Then, my Lord, I prosecuted DLD, that is 2 years course, to distance education mode in National Institute of Open Schooling. That is for the session 2017-18. So course was completed in 2018. My Lord, I appeared in March 2019.
Course was completed means what?
My Lord, 2 years course, I completed the course of DLED. That is a 2 years duration course. I completed the course in 2018, 2017-18. Then, my Lord,
marks was
then, my Lord, I appeared in the examination in March 2019.
Completion of the course.
I prosecuted my course, DLED course.
Apex Court said,
yes.
What is completion of course?
Completion of course, my Lord, I completed 2 years course, and thereafter
it should be declaration of result.
Declaration of result.
Yes.
My Lord, I appeared in the examination in March 2019. That is prior to the cut-off date.
March which date?
March. My Lord, Annexure 1, Your Lordship may kindly see. Annexure 2. Your Lordship may kindly see the mark sheet which I obtained from website. That is under Annexure 2.
I'm simply asking the date.
The date is only they have indicated March 2019. Annexure 2, Your Lordship may kindly see.
Makes no sense unless it is answered.
No date is there.
Then you can't say that. It's in your favor.
But March 2019,
it can be after 19/3. 31.
But a date, I got that from the website, but the date is not there. That is March 2019. And although I got it from the website, and I secured 45% of marks.
It is not 50.
It is not 50 in class 12. But I completed the course prior to that cut-off date. But so far as class 12 examination is concerned, since initially I secured 45% of marks, the requirement is 50. Therefore, I appeared in the improved examination to improve my marks.
It is subsequent.
Subsequent. That is on 6/6/2019. That was 53%.
This period.
But so far as that stipulation, that cut-off date is concerned, that is for completion of course of training before that cut-off date. I completed the training and I also appeared at the examination. But so far as my +2 marks, where initially I have secured 45% of marks and subsequently 53% as per the requirement, and I uploaded that. Then Your Lordship may kindly see their counter. They have admitted that. In the counter, they said,
in that LED course you completed it successfully.
Yes, yes.
Yes, true.
Yes.
He has completed successfully, but because of his ineligibility, NC has been marked.
Where is ineligibility? Your course is to be completed before 31/3.
Yes.
Not PUC.
2019, 31st March 2019.
Before that he has done.
He has completed.
Yeah.
But he may have been marked passed, but certificate could not be issued because NC not certified. The reason being that he did not have the minimum eligibility at the time of entry.
That is related to that
last
one.
12, he successfully completed that 53%. He brought up subsequently in April
+2.
In 2019.
6/6/2019, I passed +2 examination.
No, for admission to this LED, etc.
Yes.
What was the requirement?
Well, the requirement is
second class +2.
+2.
You
But
did
that
not
has
have.
been, but that has been relaxed.
That is relaxed.
Yes, your Lordship may kindly see their counter. That is my case.
No, from counter we cannot decide.
No, my lord,
Document should decide.
I have also annexed. that. Your Lordship may kindly see my rejoinder. That is
the
the
relaxation.
Yes,
Relaxed thereafter in the subsequent. No, the question is from the court. So you may allow me to say. The relaxation came last year when the Ministry of Education, Government of India said that 50% eligibility criteria will be relaxed down to only pass in class 12. So that doesn't apply to him.
No.
Subsequent.
My lord,
Is it with retrospective effect or
No, not with retrospective.
that is prospective. Your Lordship may kindly read the letter dated 3rd August 2017. That is under Annexure 5 to my rejoinder. Roman 14. The teachers who do not fulfill, my lord got it?
Yes.
The teachers who do not fulfill the minimum eligibility requirement for taking admission in DLED program, that is 50% in class 12, will have to join NIOS, National Institute of Open Schooling, and reappear for the class 12 examination to achieve the minimum qualification. They would, however, be eligible for provisional admission in DLED program of NIOS, subject to them acquiring 50% marks in class 12 before
completing the program.
DLED program of NIOS. This would facilitate such teachers to pursue the programs concurrently.
But you did not get it before.
But when I passed initially,
it was 45.
It was 45.
Yes.
I improved my percentage of marks.
That should have been before.
But
that is the meaning. Otherwise, teachers who do not fulfill the eligibility requirement would have been teachers who have not fulfilled the eligibility condition. This is prospective operation.
Why this has happened? They themselves have fixed the cutoff date. Your Lordship may kindly see.
Nothing.
Your Lordship may kindly see the counter.
What counter? This very policy says like that. Even assuming that in counter they agree you should be given. I cannot give. This is a writ court. Writ court has to grant relief based upon the law, not upon the stand taken by the parties.
And for your Lordship's information, we have never admitted. We have never admitted in the counter.
No. I have. Your Lordship may kindly see one paragraph of their counter. They have issued the certificate. They have, from the website, I have collected the mark sheet.
Give the paper. Hard copy.
Your Lordship may kindly see paragraph 7 of my writ petition. They themselves fix the date for online updation of marks of class 12 by 11/10/2019. They have not denied it. Para 7.
That makes no sense.
Para 7.
No, that makes no sense.
But because of pandemic COVID-19, date was extended. Your Lordship may kindly see. I have categorically stated.
Date was extended for what?
For updation of marks of class 12. Those who have secured less than 50% of marks.
Where is that?
Para 7 I have stated, they have not denied it.
No, that makes no sense. This is all by all policy. petition is rejected.
Your Lordship,
by getting
Your Lordship,
another 5 paragraph. So in Albert Charles.
One paragraph. Your Lordship, kindly permit me to.
Petitioner completed the at the time of admission, petitioner exactly less than 50%. Second, in terms of the policy decision, it was required to be 50%. Petitioner could make out this 50 only on 6/6/2019, that is beyond 31/3/2019, prescribed for completion of the subject course was dismissed. Next.
Item 39 has been addressed. Item 40.
I may be pardoned, Your Lordship may mention my.
Yes, sir. This is only the reasoning. Once judgment will come.
Minus.
Yes. Next.
Item 40.
The case of legal malice. It's the case of legal malice. While implementing the court's order, these people were terminated and they had approached the Lordship.
Implementation of the court orders.
Yes.
Not implemented.
We have implemented the court's order. While implementing the court, giving appointment to some of the petitioners, those who have secured more marks there, they got the appointment. These people were out of service because in their place,
they have challenged this.
Time in this.
40 ଆପଣଙ୍କର ନୁହେଁ?
Hearing on some matters.
4044 in some matters.
Other expire. All right. We'll call this matter in the second week of December. You cannot read the papers again and again.
Series of matters are there. Series of matters are there in 40 analogous matters are there.
Again and again. There's not that attack by that untamed. My knowledge. Yes.
Item 41 has been adjourned. Item 42.
Well, what about item 40 minutes?
Yes, sir.
Well, am I audible or not?
Second week of December.
We can on 10, 12, 40.
10.
Item 40, I am for OP number 5.
10, 12.
10 December.
Any other date you want?
No.
Yes.
My learned senior is appearing for the private opposite party.
In that
is mentioning, my lord.
Sir,
in the same matter.
There is bereavement. There is bereavement in the family of one of the lawyers arguing. Therefore, arguing counsel is absent.
Okay, then I am. What date and which date it may not have urgent? 10th of December.
Item 42.
Well, this case is virtually covered by your Lordship judgment. It is passed away. But here, the petitioner pursuant to the advertisement dated 23/12/2021.
Judgment.
That special be it. My Lord's judgment. Here my
Mr. G.
My lord.
This judgment is not put in appeal.
I have no instruction then. I do not know, my lord. Just now I came to know that such an order.
Next week I saw this.
My lord.
Just verify it.
Yes.
Covered by the judgment.
Yes, covered by the judgment and subsequent judgment also.
So that was that day again.
Yes.
Yes.
Item 43.
Last September, your lordship has given the task that to find out a particular decision regarding opening of private school. I feel myself deficient and financial. I couldn't get that particular judgment. Your lordship was referring, but just giving a hint that there is a decision. I have thought minor, but I am extremely sorry I couldn't find out.
You could not find out.
I couldn't find out. But your lordship was referring that there is no hurdle for opening of liquor shops. But why there are so many hurdles for opening primary school?
Because it is, I have mentioned it in that judgment.
Right. But I will assume I couldn't get that judgment.
ପାୱାରଟା ନାହିଁ ତ ମୁଁ
Dixit on establishment of new schools.
But instead, I have got another decision in way of subject. Your lordship, can you recollect? My friend was raising an objection on the other day that 2 other schools have been opened in the area. Therefore, my school, no further consideration will be made for my school. To cover that, I have got another Karnataka decision. It has said that a particular notification was there, a change of policy, but the conservation arose before that letter was issued, policy was changed. Therefore, that policy will not be applicable. My case is, my application is pending since 97, and in the meantime, if some further schools have been maintained, that cannot curtail my claim for getting a permission to open the school.
And actually 17 में kindly will send. I'm placing that.
Thank you.
आप किसी पाएंगे? आप submit करिए.
No, अच्छी सुनो. Before actually kindly recollect that last occasion I have submitted a note. I want to place certain.
I'll come after lunch hour. I am not that well today.
Right.
Item 49 is the absent after lunch. Can you add them? 49, yes. I am on the petitioner. I have some person who have after lunch. I will not available.
Council has not been
Council might not have, my friend is not.
I'll also.
You want time? I want time. Second week of January. I cannot. There was an interim order that should. Interim order to continue.
I got 51, madam. 51. 51, I want 1 week time to file counter. I have for the OP number 4.
51 also. You want 1 week time, which is that matter?
51, my one friend is there.
Yes, 51.
51. I am
second week of January.
I am one of the opposite that my name does not appear in that case.
51
print his name.
Some law, also date matter because this is going to retire.
When he is retiring? You said you will be after 6 months. You will be retiring.
No, that is not that matter. This is another.
When is he retiring?
Next month, January or February.
February.
Because it's a covered matter.
Second week of January 2026. Anyway, retirement will be last day after January.
From principal matter. Now, if you retire, then you will not get the benefit.
No, before that it will be decided.
Yes.
Item 46, Your Lordship. I am hearing one of the opposite parties. I will file a counter.
46, sir.
My Lord.
Who is the
petitioner? I pray also take up this matter because this is a conducted matter, and I am the trustee, charitable organization. Now I am disclosed from the management by the collector since 2023. Since 2023, you want to take up the matter.
Truly not possible because the learned senior advocate wants objection to file. So in the second week of January, third week of January 2026.
Yes, December can also take up.
December, most of the dates are December.
Along with the connected matters,
I really would have fixed the date. I should hear all of you.
Along with the connected matters, Your Lordship.
I'm giving the number
call along with
276225.
I just read. Write down it.
Your Lordship, I'm appearing for opposite parties 7 and 8.
For the reservation of seat at Puri, but the seat could not be reserved for some reason. And since last day, 2 days of counseling is left, the matter may kindly be taken up.
Matter has not come up.
No.
Matter is scheduled to 16th December.
16th December, they have put it.
He wants to postponement of the case.
Postponement, any urgency?
Yes, my lord.
Why?
Since last 2 days of counseling is left.
Counseling going on?
Yes, my lord.
Take it tomorrow. Yeah. Yeah.
Item 43.
My lord, when I was placing another 17, may I place another 17, page 108?
What is the case about?
Case is regarding the recognition of a girls' high school, which was permission was granted, temporary recognition was granted, temporary recognition was not renewed after several applications. Ultimately, the permission was rejected.
For establishment of school, permission is rejected.
Yes. First permission was granted, then temporary recognition was granted. But 2-3 years temporary recognition was granted. Ultimately, temporary recognition was not further granted and permission was rejected. That is another 17. I'm letting place. My friend was placing another 17. Let him place another 17.
No.
That is the imbue judgment.
Permission is under which section?
Under Section 6 Education Act.
Section 5. 5.
Section
5 of the 5.
Section 6.
Section 6 is relating to recognition.
Yes, ma'am. Permission was granted, recognition was not extended.
You can't contradict Mr. Swain at all in education matters.
No, not at all, not at all.
Let us read private, whichever section you want, I will read. Which section you want me to read?
Section 5.
5. Read. Permission for establishment of educational institution.
Yes, ma'am.
No private.
The 5 stages over, permission was granted to me. Thereafter, temporary recognition was granted. But further not extended. That is under Section 6.
So you have crossed the Section 5.
Yes, madam.
Yes, crossed Section 5. We agree with that. Go to Section 6. You are stuck in Section 6 now.
Yes, madam.
Yes. Read Section 6.
An application for recognition of a private educational institution shall be made to the prescribed authority on or before 31st November of academic year in which the institute starts functioning, provided that no application for recognition filed before commencement of Old Education Act 12 shall be rejected only ground that it has not been filed within date respect. Explanation not required. No private educational institution shall be eligible to recognition unless it has been established with prior permission under this Act. I have established with prior permission. Every application for recognition shall be made in the prescribed form accompanied by such document and information as may be prescribed, and applicant shall furnish a statement indicating the extent to which the conditions specified in the order granting permission and condition for recognition as specified under Section 6A have been fulfilled. Every such application shall be supported by affidavit attesting the fact that all information furnished there are true and correct to the best of the knowledge and deponent. Your Lordship may kindly skip to Section 9.
No, Section
9.
6.
Section 9, Subsection 9. Where a private educational institution has not fulfilled the conditions for recognition in regard to the land, building, furniture, but the committee is satisfied that it has been made reasonable, adequate provision for accommodation and imparting education. It may decide to grant temporary recognition for a period not exceeding 1 year at a time and not exceeding 7 years in aggregate. The application for extension of temporary recognition shall be made and considered in the same manner as an application for recognition, and no extension of temporary recognition shall be granted unless the committee is satisfied that the applicant has taken reasonable measure. I repeat, reasonable measure to fulfill the concern for recognition and that there has been no deterioration in the standard of facilities during the year for which the temporary recognition was granted. I am here, my lord.
You are here.
Yes, ma'am.
What has happened actually?
Page 108, the impugned judgment.
What subsection 9 says? You have read it now.
Pardon?
You have read the subsection 9.
Yes, ma'am.
What subsection 9 says? You have read it so fast that you could not grasp the letter from that.
Extremely sorry, ma'am.
No problem. Just look it.
My effort is to overcome that, and I am stuck in that.
No, since you want to bring your case within the parameters of subsection 9.
Yes, ma'am.
That we should understand. Both we should understand.
Right. Absolutely right, ma'am.
So it speaks of the temporary recognition.
Yes, ma'am. I am telling temporary recognition was
for a period of 1 year.
Yes.
Provided that the committee is convinced that you have made all accommodation, etc. Though you do not own them.
That is accepting land, building and infrastructure. Furniture. Land, building and
building, yes, you are right. Land, building and furniture. That accommodation.
Those conditions are not fulfilled and other conditions are fulfilled. Then
also
for a period of 1 year.
1 year, which can be maximum 7 years.
Right.
So within those 7 years, you should provide those things.
Right. Absolutely right, ma'am.
To get regular recognition.
Absolutely right, ma'am.
Have you got that?
Yes, ma'am. I am satisfied, Your Lordship. Therefore, now may I draw your Lordship attention to the impugned order. That is on page 108.
108. What they said?
Paragraph 2. Page 108, paragraph 2.
ପୁରାଟା ପଢିଦେଉଛି ମୁଁ ପଢିଦେଉଛି
ଠିକ ଅଛି ମୁଁ ପଢିଦେଉଛି
ନା ଆପଣ ମତେ ଦେଖନ୍ତୁ ଆପଣ କାହିଁକି ପରିଶ୍ରମ କରିବେ
ଠିକ ଅଛି
ମୁଁ ପଢିଦେଉଛି ଆପଣଙ୍କ ପାଇଁ ମୁଁ ପଢିଦେଉଛି
Okay.
You are agreeable with his proposition now? To read or to allow the case itself?
No.
For reading.
Only to help him.
Very well.
In due obedience to Honorable High Court of Orissa judgment dated 24/8/2022, passed in WPC number 13,756 of 2019, filed by the Managing Committee of
contempt, etc.
My lord.
OP number 2 is
instructions. High power committee, my lord, was formed, and matter was heard by to the chance of hearing was given to the secretary of the managing committee. The report of the district education officer Noyagarh, second paragraph, my lord, submitted that the letter number 91/2023 was placed before them.
Niagara is in America, in also Niagara Falls.
No,
Niagara.
Yeah.
Was placed before them by the concerned branch officer of the directorate. In response, the representative of the managing committee did not utter a single word contradicting or contesting the findings of the joint inquiry conducted by ADO Noyagarh and ABEO Daswalla. Furthermore, the headmaster in charge confirmed that the observations of the inquiry team that the school has no land of its own. And it is only after recognition of the Secretary Parikshita Jani will register the land now being used by the school in the name of the school. The school is without any student since last 5 years. There is only one classroom available and its condition is not good. The school is bereft of minimum basic infrastructure like toilet, like playground, library, electricity, etc. The school records are not in shape, but they admitted they had failed to produce any records to the joint inquiry team on 7/1/2023. As regard to the query as to why they are filing repeat litigations despite no viability to run the school, then they had strange answers and intent to keep them alive, to show up their strength before some ministerial staff in the office of DEO Noyagarh, who they think
are instrumental in the refusal of
refusal. Over. One more page is not
one more page is there. 109 sir, 109 पढ़ो तो अपनों पर.
109 do you have? I also don't have.
I'm extremely sorry, my lord.
No, it's all right. Give it. No problem. Sometimes it happens, na?
My copy.
Take one Xerox copy of that. Make 2 Xerox.
Only 110.
110 is there.
No, extremely sorry, my
lord.
No. One thing, I should have uttered it very fast. Very beginning.
No problem.
Then I beginning other point. I am beginning. Apologize, my lord.
No, you need not apologize. You are elder to me. You need not apologize to me. You are elder to me. Bar members are. I treat them as elder to the court. All way up.
One point, my lord. I don't hold power for the petitioner. The petitioner power holder is Mr. Moon, whose daughter's marriage is tomorrow. That fact I should have uttered fast.
So that marriage will take place properly.
No. I got.
Do you want to go there?
No.
You are not.
I want to repent him. I don't have power. I will disclose it to your lordships.
Okay.
Because the mood is incapacitated, therefore I have.
What I suggest is.
Yes.
We will have this matter after the marriage and before the childbirth. Before your friend becomes grandpa.
No, I am prepared to do.
You are prepared. But it appears matter appears to be weak, prima facie. The marriage ceremony is going on.
No, may not be there. I will not go there. 400 kilometers away at Bhawanipatna.
At least you will not inform him that this has happened in the event in this case. Anyway.
That is at Bhawanipatna. 400 kilometers away. I may not be possible for me to attend there.
That's all. Now they are saying
yes,
you don't have building.
I am conscious. I will start my case from that.
No, do you have building?
Pardon, madam?
Do you have your own building?
Yes, madam.
You have one building?
Yes.
Where is that document?
At the another 19.
Another 19. You bought that building when? Give the date of registration?
I'll come to that. My note I have
date of registration
mentioned that in my note.
26/2/2024.
Yes, madam. That is the registration has been done.
The date on which this impugned order was passed.
Same day.
Same day.
Well, that sale deed is done. The sale deed is dated what?
Sale deed is dated 26/2/2024.
24. At least if the sale deed was a bit earlier.
It was not with the knowledge of, yes.
So it would have taken that there is one section in Registration Act, no? Registration Act 1908, where deed compulsorily registrable, a document compulsorily registrable is presented. It will take effect from the date of its execution once it is subsequently registered.
Right, madam. No,
this is registered on which day?
25.
Same day.
Same day, 25.
But that you did not tell them that you own this land.
Again, madam, I don't dispute that. I will again draw your lordship, beg your pardon, madam, draw your lordship attention to page 108. Again, that particular paragraph, I want to draw your lordship attention.
108.
108, paragraph 2. The same new page. The new page. Which was missing, the lordship got it.
That is 110.
109. Yes, 108.
109.
109 was used. 108, I want to place.
Again.
108, I want to place. Paragraph 2.
Paragraph 2.
In the report of the DEO, I got submitted by letter number so and so was placed before them by the concerned branch officer of the Directorate in the response to the representation of the managing committee did not utter a single word contradicting or contesting the finding of the joint inquiry conducted by ADEO Nayagat and ABEO Daspala. Furthermore, the headmaster in charge, I want to draw your attention to this particular sentence.
Confirm the observations.
Confirm the observation that the inquiry team that the school has no land of its own. And it is only after recognition the secretary Marikita Jani will register the land now being used by the school in the name of the school. Only the school is having its land. School is having its building, but no title. Title passed on 25 because he denied that I will not transfer unless your school is registered.
When the hearing happened?
Pardon, my lord?
When the hearing happened, Mr. G?
Hearing happened on 24/8/22.
24?
No.
No.
Hearing is 28th April 23.
No, that is 24/8. As on that day,
Yes, madam.
you did not have the sale.
I didn't have the sale deed, but I have the land, I have the building constructed over
That we don't dispute.
Right, man.
You
Then-
have this land as on the date this order is made.
No, like no title, that is already right. But I am drawing again your lordship attention that the statement of the headmaster that the school has no land of its own and it is only after recognition the secretary Parikita Jani will register the land. He gave an embargo, he donated the land. It embargo that unless the school is registered, I can't make a shelter in the name of the school. First get it registered, then
But law says.
Yes, law says, right? Law says, all right, I'm conscious. But my vendor says that unless you get the recognition, I will not transfer. He gave the land. We have made the construction. That I will double lordship attention. One particular paragraph. Another point is there in page 108. School school.
You don't have any students since last 5 years. Sir, since last 5 years, you don't have any students.
Yes, I admit it. I'm conscious of that. Therefore, I'm drawing your lordship attention to two further points. Here, the book school library. Anyway, I don't find it immediately. There's another objection from the raised from my friend that in the nearby vicinity there are two other schools. He has not pointed out, but I'm raising it. He has an objection that there are two other schools.
He has done this. Whether in the impugned order they have said that.
In the counter they have stated there.
No, counter they cannot do that.
So therefore, I am drawing your lordship attention to my rejoinder.
No, that makes no sense. In counter they cannot say. This order is the order.
Right.
In counter they may say all the novels, stories and history.
Then, madam, may I draw your lordship attention to the note I have submitted on the previous date.
That's fine.
A note I have submitted on the last previous date. I want to place
note.
Yes.
No, I understood the case.
No. I have some further points, madam.
You mean to say I have not understood?
No, you must say some further points. I say that some further points.
No, I'm just thinking in your favor, so that because the establishment of school will help the children.
Yes, madam.
Help the society.
Yes, madam.
Therefore, they have to give very strong reason for not allowing you to have this.
Yes, madam.
With that assumption, I am feeling I could not locate since my health is little upset, I could not immediately locate my judgment. Who is there?
One thing, madam, if this paragraph, I again insist, madam, with all respect, may develop the adjudication. One particular paragraph of my note.
Sir, ଆଉ କୋଉ ଦିନ ଗୋଟେ କରୁନାହାନ୍ତି ଦିନେ ଦି ଦିନ ଛାଡିକି ସାରଙ୍କ ଦେହ ଟିକେ ଭଲ ନାହିଁ ତ ତେଣୁ କରି
No, I have not understood. What is your
My welfare suggests that I was adjourning because your lordship is not feeling well.
No, I am not adjourning. I am ready with this matter. Anyway, I have heard it halfway through now. Understood. Now, Mr. G, whether there are students or not, if there are students, well and good.
Yes.
This becomes a fresh application because now he has obtained title to the land.
Yes.
Therefore, although the order was right when it was made,
yes,
because that was not brought to their notice, matter was heard a few days earlier. So best way is to remand the matter for fresh consideration in a time-bound way. Now because new parameters have come now.
Yes.
They have acquired the land.
Yes.
And other things, whatever
other requirements, my lord.
They will comply with that.
If they will comply with other requirements, then recognitions will be given. But nowadays, it is my, I am to search for that letter, my lord, whether they were giving recognitions for newly schools or not. That
if there is a policy not to give,
my lord,
you reject it. But you have rejected not on that ground.
No, this is not that ground.
That is not the ground. Therefore, this ground is now, they have produced, what all they have to produce under that? For provisional, temporary, well and good.
Yes.
What is done is well and good. Beyond 7 years, it cannot be. Now he is entitled to have his application as a virgin application.
Yes.
That you treat it in accordance with law.
Yes, as a new one.
That is what I am going to state my. That is what I am going to state my.
Therefore, I have said it.
beg pardon, madam, 2 paragraphs, permit me please. Only 2 paragraphs. In my note, paragraph point number 7, I'm reading. 21/5/2012, the annual inquiry report by the block level VEO, inquiry report dated 16/5/12 was submitted, another 5 page 36, indicating that acres on 3.01 decimal land of donor, 2 classrooms, headmaster office, staff common room, 41 students admitted, 8 staff including headmaster, science instrument, library books, desks and bench, teaching aid, tube well, drinking water, storage and toilet, SC/ST dominated area, girls high school is necessary. That is their report, madam.
That was on
21/5/2012, another 5 page.
But subsequently, that was more than a decade ago.
And now they say that there is no student, no infrastructure.
May not be.
Their report says that it is there, madam.
No, it was there. When Babar came, it was there.
I have given photographs. I have given the photographs of the school building.
True. At during that time they were there.
Right. In second part, that no student is there. School has been, recognition has been stopped for 5 years. And for last 5 years, without recognition, there is no students. That's what I have no students. And my last paragraph of the note is, I didn't predict your lordship's view, but I have mentioned that since last date. Another 19, page 139, ROR of the school, plot 40 decimal, the land in the name of the school cannot be transferred to anybody else. Prayer for fresh application with the temporary consent. That is my last paragraph of my note. I also prayed that say, all right, or you have stopped the consent, there is no student for 5 years, but all this staff I have appointed, all the appointment letters I have annexed to my annexure. So now that let me apply afresh, let my case be considered afresh. And one thing,
provided you fulfill the criteria.
I understand that if all criteria is there, well, except by the ROR. The ROR was there.
ROR is also not sufficient. It requires 4 acres, 540 decimals.
3.140, earlier 3.1, para 7, 3.1, para 19, 40, para 19, 40.
4 acres is the minimum requirement.
That
minimum requirement is how much?
4 acres.
Where is that? That 4 acres, where is it mentioned?
It is there.
That is under the rules.
Under the subject rules.
Urban area and rural area different.
Different areas.
Depending upon the area where the school is established.
Urban area and rural.
Okay. Urban area because they thickly populated, costly land, etc.
That is 2
acres.
It is 2 acres. So far as in rural areas, it is 4 acres.
But this is from rural area.
Rural area. It is rural area.
That is the requirement. Then dismissal. Then I have to dismiss it. Because admittedly you do not. Then what benefit you will get by remanding the matter? If they take up in appeal, the division bench will issue shoka notice to me.
One single point I can take. That is, right now probably my school has been allowed to be established, and that was temporary recognition.
Temporary
recognition. I say temporary recognition. Temporary recognition was not renewed for want of infrastructure. Now that I have got the infrastructure,
where is the infrastructure?
That land is there, building is there. Building, I am giving you the photograph.
No, that land should be of so many acres, 4 acres. But that you don't have.
I don't have.
That is for regular recognition.
For temporary recognition.
But so far as temporary recognition is concerned,
4 feeder schools are also there.
So far as temporary recognition is concerned, under Section 6 of the Orissa Education Act, if it does not fulfill the condition relating to land, building and furniture, and other conditions are fulfilled, then temporary recognition can be granted.
But he sought for regular recognition.
He will not get.
He will not get.
Unless conditions are fulfilled under Section 6A of the Orissa Education Act.
My last prayer for fresh application with temporary recognition.
Now, what Mr. Swain says now, it may help you.
Yes, madam.
Provided you make application for temporary.
Yes, madam. That's what I say.
Let him make temporary.
That's what I say.
All this problem arose because you applied for regular recognition.
That was the time when I got a temporary recognition.
Anyway.
My temporary recognition, another fault, my non friends.
Petitioner's application for grant of regular recognition contemplated under section under section 6 of the Orissa Education Act 1969 having been negatived by order dated 26/4/2023, this writ petition has been filed for laying a challenge thereto. Kindly be seated. Kindly sit down, Mr. G. First off, the relevant part, that is namely the second unnumbered paragraphs, second and third unnumbered paragraphs in the impugned order read as under. Next paragraph. I just mark this one. Just reproduce that. Learned counsel for the petitioner vehemently argues that in terms of the provisions of section 6, the authorities ought to have granted a regular recognition, land having been bought while registered sale deed dated 26 February 2024 and other requirement having been complied with. He also cites a decision of Karnataka High Court in Livy. I'll point out that. To the effect that the approach of the authorities for intended establishment of educational institutions should be pro-establishment. So that the social need for education is catered. Especially when right to education has been declared to be a fundamental right by the apex court in Mohini Jain versus so and so. In that right. First time. This approach having not animated the impugned order, the same is liable to be set at naught. First, Miss Mohini Jain versus State of Karnataka. The year 1992, SC 1858. Next paragraph. Learned AGA Mr. G appearing for the OPs, having filed the counter, resists the petition, making submission in justification of the impugned order. First, he contends that the required land area as prescribed under the extant rules is 4 acres.
No, that is 3 acres.
3 acres.
Rule 15.
Under Rule 15.
Rule 15 of the Orissa Education Establishment, Recognition and Management of Private High School Rules 1991. Page 642.
642.
642 of that manual.
642.
And for urban area, 1 acre. Rule 15B. It must be located in a site measuring not less than 3 acres if situated in a rural area, or a site measuring not less than 1 acre if situated in an urban area, and must possess the title over the site.
What you have written now? Under Rule 15, under the provisions of Rule 15, Rule 15B it is.
Yes.
Rule 15 small b of Orissa Education ERMP HS bracket complete rules 1991. That book, just book looking page 642. Okay, and full form, long form has to
636.
636. Yes, got it. The required aerial extent of the land has to be minimum 3 acres. Whereas the land bought by the petitioner is how many acres? 2 acres.
No. 3.1 plus 3.1 plus 40 decimal. 3 acres, 41 decimal.
Yes, fulfill that requirement then. Mr. G, that may not be the contention, may not
necessary, may not be fulfilled, because
this is the petition making submission in justification of the issue. First, next one. Having heard learned counsel for the parties and having perused the petition papers, this court is inclined to grant a limited indulgence in the matter, in as much as the impugned order proceeds on the premise, on a factual premise, that the petitioner does not own the land at all. And when he does, by virtue of registered sale deed dated 26 February 2024, a copy whereof is available at Annexure.
Another 19.
19. Annexure 19. First, the second ground earth.
Annexure 18.
18.
I beg your pardon, another.
The second reason mentioned in the impugned order, that there have been no students, is factually true, but would not come in the way of considering petitioner's application for grant of regular recognition. If other requirements are complied, it hardly needs to be stated that without continuation of the temporary recognition, there could not be any students is obvious. First off, petitioner's counsel drew attention of the court to the report of 2012, which mentions about the running of classes and of the students. First off, that may not be relevant now, more than a decade having passed away, having rolled away. First off, be that as it may, the impugned order is fraught with legal infirmities, and therefore it is liable to be invalidated. and matter requires a fresh look at the hands of jurisdictional authority on intrinsic merits. First of all, in the above circumstances, this petition succeeds in part. 7. A writ of certiorari issues quashing the impugned order. 7. Matter is remitted back to the portals of Directorate of Secondary Education, Odisha, Bhubaneswar, for consideration afresh. First off, it is open to the petitioner to produce all requisite material to satisfy the jurisdictional authority that he complies with the legal requirement for the grant of regular or temporary recognition as the case may be. First, an opportunity of hearing shall be afforded to the petitioner and other stakeholders if any. First, time for compliance is 3 months. First, all contentions are kept open. Courts may cease.
My lord, by which date he will submit? They will dispose of within 3 months after receipt of all the requirements.
3 months.
That will be placed by the director before the High Power Committee will take a decision.
Okay. So therefore, he could not have taken the decision at all.
No.
Who takes the decision?
He has to recommend.
He can recommend.
Director
decision itself is taken by the director here.
No, High Power
Committee has taken.
That is another ground actually.
Yes. No. Well, this order was passed by the High Power Committee after yes. Annexure 17, your lordship may kindly.
Your lordship may kindly see section 6. That is before.
The High Power Committee has to take away. It's not by the High Power Committee.
This HPC means the High Power Committee.
Means correct. Where is who are the members?
Annexure 17, your lordship may kindly have a look. In due obedience to the Honorable High Court of Odisha judgment dated so and so, and others.
Because
and instructions of the
as a member of High Power Committee.
My lord, instructions of
the prescribed authority who will make inspections.
And
Mr. G,
my lord,
who are the signatories? Only he.
Yes, because
the High Power Committee.
My lord, this order was passed in response to your lordship's order.
That's all right.
Yes.
But the point is, to say it is a High Power Committee, then it partakes the character of institutional decision.
My lord.
But it is individual decision.
So that will be communicated by the prescribed authority.
My lord.
That is the director.
Let me.
That way.
Director.
My lord, I am.
Lordship may kindly see section 6(4). The prescribed authority, page 126. Prescribed authority shall scrutinize the applications, such of the applications as are found to be complete in all respects and have been submitted in conformity with the provisions of the Act and the rules, shall be considered, and thereafter the prescribed authority shall inspect or cause to be inspected the educational institution in respect of which recognition has been applied for, and shall make a report with his recommendations, which shall be placed
constituted by the state government.
Yes.
Where is that committee?
The committee is there.
No, that decision by the committee.
Yes. That committee is there on record. My lord, here, my lord, this order which is under challenge, this annexure 17, my lord, this order was passed by the Director of Secondary Education.
Correct.
In compliance to your lordship's order.
No, that's wrong.
Yes.
That's wrong.
No. Your lordship may kindly have a look.
No, this order, Mr. G, the order should say the committee takes this decision.
Yes, they have said that.
Where is that?
My lordship may kindly see subsection 6. Subsection 6 of section 6, 126. The committee shall consider the application for recognition.
Committee has to consider.
And thereafter the prescribed authority will communicate in the same.
The prescribed authority is only a postman.
Only a postman.
My lord, lordship may kindly bear with me for a moment.
Well, that is there.
It is
secondary education and
it was considered. It was considered, my lord. It is not
committee.
Yes.
Where is that?
It is there in annexure 7. I'm holding this. Well, my lord, it is annexure 17. In annexure 17 and in first paragraph. My lord,
17.
3, 4. My lord, 4 lines, my lord. Contempt number so and so and instructions of a high power committee in the meeting dated 11/1/2023. The director secondary education Odisha, who is opposite party number 2 in the writ petition, gave a hearing to the miscase of managing committee of Jayanti Patnaik Girls High School on so and so. So it was considered by the high power committee.
No, who heard?
My lord?
Who heard? Hearing person is one authority, decision maker is another.
No. Your lordship directed to take a decision.
By whom?
By the director.
Wrong.
No. It was there. What can I do?
No, what you say is factually correct. But point is, in Gullapalli Nageshwara Rao versus APSRTC, the Supreme Court said, one who hears, he has to take the decision.
Yes.
Unless the law authorizes that other person to hear and submit a report to the concerned committee.
My lord, this matter was it was placed before the high power committee in meeting dated 11/1/2023.
Correct. Understood. Agree.
Thereafter, my lord.
But who heard?
My lord,
the director heard him.
Yes, the director, in compliance to order dated 24/8/2022.
This is to be taken by the High Court Committee.
Please. This complies order dated 24/8/2022 passed by the Honorable High Court in WPC number 13,756 of 19 and order dated 16/12/2022 in contempt number 7.
That makes no sense at all.
My lord.
You are referring to the case.
Yes.
Question.
Because I am referring to because the director secondary education has passed this order.
You cannot.
My lord, yes. My lord, in compliance to your lordship's direction.
Even then direction should be understood in the light of law. If such a direction is given, you should have told the court, sir, I am not the person who can take the decision. Decision has to be taken by the committee in which I am also a member.
My lord, that is what we have done that. Because at the time of taking decision, my lord, in order to implement your lordship's direction, your lordship directed to give a personal hearing. That was given by the director.
No, director cannot give. Therefore, I am telling you. Gullapalli Nageshwara Rao, you have not seen that.
My lord, thereafter.
Which is that? Gullapalli Nageshwara Rao versus APSRTC or APSRTC versus Gullapalli Nageshwara Rao.
High power committee.
Andhra Pradesh.
My lord, high power committee also have taken a decision on 11/1/2023.
The perusal of the order, impugned order, does not exhibit that an institutional decision has been made by the high power committee. Although learned G says it to the contrary, says the contrary. First off, this apart, the opportunity of hearing was given to the petitioner by the director. And if the decision were to be taken by the high power committee, as is sought to be made out by Mr. G, that would fall foul of Gullapalli Nageshwara Rao versus Andhra Pradesh, state of Andhra Pradesh. They are 1959 SC 308, which is that sentence. One who hears should decide. First, this is added infirmity in the impugned order. First, G's vehement contention that in the earlier round of litigation, a coordinate bench of this court had given a direction to the concerned authority, which he complied with under the threat of contempt, would not serve the requirement of law, even if it is true. First off, it hardly needs to be stated that orders of the court have to be construed in the light of provisions of law which relate to the fact matrix treated by the court. First, in the above circumstances, this petition succeeds in part. A writ of certiorari issues quashing the impugned order. First, matter is remitted to the High Power Committee for consideration afresh within an outer limit of 3 months. 3 months. First, it is open to the petitioner to produce all requisite material before the High Power Committee within a period of 6 weeks from this date, along with a fresh application, if need be. No, not fresh application, because the remittance is along with delete along with. All contentions are kept open. Cost made easy. Yes.
I have given my name in a cheat.
Huh?
My name I have given in a cheat.
Yes. First name we should bring that in. Okay. Yes, sir. You can attend the marriage now. Yeah.
Item 44. This is the case of Hon'Ble son of a district primary school teacher, my lord, and covered by Subarna Dibya case, my lord. And the lordship, my lord, referring the Subhasini Patnaik case, my lord, which has been passed by the coordinate bench, my lord. Your lordship has passed the order, my lord. So I have
similar matter. Mr. G, just have you said a copy of
my lord, I have a copy. And also,
everybody will say covered by the judgment, but how we will know? Only consider.
My lord.
Rules obtained and yes, sir, because of the amended
my lord.
which other day.
Subarna Dibya's case.
My lord. Subarna Dibya.
There is a cut-off date.
That you have to put a cut-off date also as it is. Okay, let's hold on. Yes.
Item 45.
Yeah, I am for the accountant now.
You are for the accountant general. Yes, the only consideration is so. Then your field is name. States 6 months. Okay.
Item 45.
Well, in this case, the petitioner is a retired government teacher. Petitioner is a retired government teacher. And pursuant to Annex 3, that is the advertisement notification of the DW Balesar Mayor, applied for the post of temporary guest teacher.
Temporary guest teacher?
Yes.
That post?
Yes. Annex 3, Lordship, kindly see. Page 20. Applications are invited in prescribed form Annex 3 for the post of guest teacher against the 9 vacancies in SSD high schools and 12 vacancies in Sevashram and Ashram School of Balesar district. I am coming under the second column category. Serial number 1, SSD high school.
Serial number 1, SSD high school.
The first is SSD Sevashram and Ashram School category, and second category is vacancy in SSD high school.
7 plus 2, 9.
Yes. But I am coming under the TGT Arts. Guest teachers required against the post of TGT Arts.
7.
Yes, 7.
Under 7.
Yes. My lordship, kindly see next page, page 21. The B terms and conditions, Roman 6.
Is
that the maximum age for guest teacher at the time of engagement shall be 62, and the retired teacher engaged as guest teacher shall be resentenced on attaining the age of 65. Well, the all requisite documents I have submitted before the authority, and my documents have been scrutinized. And as per the mode of selection,
how long you will continue?
Up to age 65.
Huh?
Up to 65. They can continue.
65. No. What would that mean?
Roman 6.
Roman 6.
Yes.
The age for guest teacher at the time of engagement shall be engagement 62.
Yes.
Then how long you will continue? Eternally. Like Supreme Court judges of the US.
Well, that is the advertisement. I will continue.
Under which section, under which rule this advertisement is issued?
This is by of a notification which is as Annex 3, page 20.
Under which notification, which rule? How can you appoint a person beyond 62, 65 unless the rule authorizes?
This is although a guest teacher.
Yeah, unless the rule authorizes. At 62, 65, what we will be? Lawyers will be very strong, I understand. But judges, teachers and others, they become very old. Lawyers have one great advantage. They don't age at all.
No appointment also.
Huh?
No appointment also.
No age limit.
No retirement.
They don't age at all. Aging is stopped. Huh?
The more they will be older, there will be demand more.
More demand. Yes.
May I assist? In UGC regulations, there is provision of the lecturer by aspirant officers can continue for 65 years.
65.
And thereafter, up to 70, they can be engaged as part-time or guest.
Just look into it, come back. Those Mr. Churi help him. On the next date, you just look into it, come back. Because left to myself, I am against engaging any guest. The institutions cannot be run by guest lecturer. It is like part-time pilot flying the plane. It will be dangerous. He will say, I will fly this up to Madras and thereafter I don't fly at all. What should happen to the if he goes in that pilot, with that pilot? Same thing. And the youngsters should be the object.
Here exactly that has happened. Even though there was an advertisement, but the fresh candidates were there. So for 1 to 4 is concerned, it is for others. So far the Romanic 6 is concerned, this is meant for the retired persons. There is a clause. But in the process of selection, so other persons, young persons have got the benefit of. So, my lord, how
just look into how this is permissible. I am not very sure that it is permissible. Anyway, Dr. Chudi says it is permissible. Look into it and come back.
It's not. My lord.
That is UGC actually.
But this is in high school level, elementary
level at all. So even that, then your case may be still weaker.
This is trained graduate arts, trained graduate science, and in high school level.
Who have been engaged now?
Well, other persons are there, those who have scored much better than that of the petitioner.
Two categories of freshers and retired persons.
Two categories.
Yes, as for annexed.
Any posts are earmarked for retired people?
No, man. No. But there is a provision in the advertisement that a retired person will be appointed.
But as between retired and youngsters, now they have not only that. Now those who have been selected are more meritorious than you.
Because the freshers have no teaching experience, but as per
then only you have to be appointed and freshers can never be appointed.
No, freshers were appointed. Well, I am the sole person to be appointed against the retired post, in the post of temporary guest.
No, now they have appointed the youngsters. What is wrong with that?
Because as per advertisement, there is a provision for retired person.
That you also
I have 30 years. I have
but the mangoes are taken, good mangoes are taken by the management. How can the other mango complain about that?
Well, but in the similar post in the same district, Baleswar district, there is no interview conducted by the authority. But here in this case, madam, they have conducted an interview.
They have
conducted 4 series, madam.
It's true. They have conducted interview to you. They have conducted interview to the other youngsters. They fared well. Where is their performance?
My lord, that I have filed in my counter affidavit, my lord.
Go to the counter.
Yes. My lord, at page 14.
Page 14.
Yes, sir.
Who are the people?
My lord, the present petitioner, so far the application is concerned, he is at serial number 3.
Serial number 3?
That is Umakant Barik, the present petitioner before my lord's.
Why you not recommended?
No, my lord, serially, they have applied for. Kindly have a glance to the next page.
Appointed.
Appointed persons.
Those who are more meritorious.
More meritorious than the petitioner.
Show that. Do you agree with that proposition? That those who have been selected and appointed,
I have given
are
a
more
marks
meritorious
also.
than you.
Mendes, I am not satisfied, my lord.
You don't agree with that?
No, my lord.
Just to show that.
My lord, the evaluation sheet at page 20.
Page 20.
Yes, ma'am.
This is
This is of 10 persons, my lord. Because total 14 persons has been called upon for the 7 posts, 1:2 ratio. 10 persons appeared. That I have given the details of the marks.
Petitioner does not figure.
Petitioner is could not figure out because it is at serial number 4. So far, these other marks are concerned. 10 persons are there.
My point of view, the mode of selection cannot be the same for the freshers and the retired person.
This cannot be segregated, my lord.
Can you now say that, having staked your claim for appointment under the very same notification?
My lord, since in other cases, other advertisements of the Baleswar district, the retired person have been appointed without interview, basing upon the teaching experience, my lord.
No, where is that?
It's Annexure 4 series, my lord.
No, the question is not that. Whether the advertisement says for those retired teachers there shall be no interview.
No, my lord. That
it does not say.
No, it does not say.
But the interview has not been conducted.
Interview has
only
not been
scrutinized the documents and thereafter they have been appointed. Annexure 4 series of the same district by the district education officer.
Okay.
In page 25, my lord, I have given the total tabulation sheet of 7 successful candidates.
What is the advertisement notice dated?
Annexure 3, 10/7/2023, my lord.
23.
Yes.
How many were in the field?
7 posts are there for the TGT arts. So for the present petitioner is concerned.
How many had applied?
Applied 14 persons, my lord.
Including petitioner?
My lord, sorry, 51 persons.
51%.
Yes. Scrutinized 1:2 ratio, 14% has been called upon.
Called for the interview?
Yes, 10 persons appeared in the interview.
Then appeared.
Yes, ma'am. That is at page 14.
And how many selected?
7 persons selected.
Nothing is the case, sir.
The number and everything is at page 25. Ma'am.
Take down.
Well, file a rejoinder.
Nothing, no cases. Let them. Kindly be seated. By virtue of advertisement dated 10/7/2023, inter alia 7 TGT odds posts were notified for recruitment. First, 51 candidates were in the fray. First off, regard being had to the number of candidates, comma, it was decided to call for interview in the ratio of 1:2.
Yes.
Wherein 14 persons were earmarked. First off, of them, 10 appeared for the interview, and from amongst them, 7 were selected, in which unfortunately the petitioner did not figure. First off, next paragraph. Learned counsel for the petitioner vehemently argues that his client is a retired teacher who has got abundant experience during the tenure of service, and therefore he stands as a class apart, spurning, spurning any interview process. First, in a nutshell, he submits that his client ought to have been selected and appointed to one of the posts in question because of his experience, more particularly regard being had to the age relaxation in terms of the advertisement itself. First, next paragraph. Learned AGA Mr. Mohanty vehemently opposes the petition, contending that the interview also took place wherein 7 candidates were selected and all their youngsters who had fared well and better than the petitioner hearing. First one, that being the position, he seeks dismissal of the writ petition. First, I agree with the submission of the HP. But in the above circumstances, petition being devoid of merits is liable to be and accordingly dismissed. Okay. Next point.
Item 47.
Yes.
Item 47.
The sole question is construction of bus terminal over Gochar land.
Construction of
bus terminal over Gochar land.
What is that? What terminal?
Bus terminal.
Terminal.
Yes.
Oh.
And also see the Gochar land is meant for grazing of cattle.
How many cattle you have got?
No, I am one of the villagers they have approached.
No, do you have any cattle?
Yes, I have.
Well, where have you stated in the petition?
I have not stated.
Huh?
I have not stated.
Then you don't have a case.
No. Your difficulty is there is a while reserving the land, certain procedure is to be followed. You also come to
no, correct. All right. I fully agree with that.
Yes, my lord.
What is your locus?
And we are the villagers, my lord. Because land in question.
Suppose if you were to be in agriculture, Gochar land is for go.
Yes, grazing of cows.
Grazing of
yes, that is the end.
Where are your cows?
Your lordship want, I will buy of that, I will file affidavit. It is not showing there.
Huh?
If your lordship want, I will file affidavit showing that the number of cattle are there in the village, number of villagers and all that. Because no doubt, your lordship, section 71 of the Gram Panchayat Act, land in question is vested with the Gram Panchayat. To consent, the proclamation is to be served, objection is to be invited.
All that question
yes, my lord,
will arise only if you cross the threshold. There is one judgment of Delhi High Court. A million questions may arise before the court, but court will not address them unless the right person is before the court in the right proceedings.
Yes. You also see.
Well, what you say may be true.
Yes.
What is your locus? Suppose Bill Clinton comes and says all these things to me.
Yes.
You mean to say I should allow the petition?
No, that is not.
Therefore, what is your credential? Where is the locus?
You also see that, in fact, in the capacity of villagers, number of cattle are there, and land in question is meant for grazing of cattle, that is Gochar.
That is
so while the land is question need to be.
Who are you to hold the?
We are the villagers, my lord. We are the villagers. We are affected by, in case the land
you are aggrieved by this.
Also, you say that, Lord, see from NHR 2 onwards, we bring it to the notice of the authority. Personal hearing was given, and that proceeding was initiated.
Then you take it before then it partakes the character of PIL. If you want individual hearing, you have to show your locus standi.
They are not individuals.
For PIL is different. Locus standi for individual list is different. That individual list you don't have.
So in the capacity of villagers, we file this.
The representative.
Yes.
Then it is a PIL. The counsel of the petitioner submits that his client has filed this petition on behalf of the villagers. As much as a bus terminal has been constructed on the Gochar land.
This is not bus, that is truck terminal.
Anyway, truck terminal is also going by the petition governments and the submission at the bar, this is a social action litigation, arguably, and therefore posted before the roster bench. If second set is filed within 2 weeks, it will go before the first court.
Last occasion, we also heard this matter.
No, but I'm not.
Last occasion also put this question. No, it was not placed. In fact, that question is not raised.
Anyway, now I say that. Yes.
Need to be placed before the division bench.
DB. Yeah. Because you only said it is on behalf of the villager.
Yes.
What else is required for me? Yes, I believe you. I am not dismissing because I have no power.
The sole question is, by the time site selection committee was told, it has lost its validity.
Next.
A defective site selection committee.
All that can be ground in the first court. Yes,
It may please your lords.
yes. Sir.
Let the petitioner has challenged the order of rejection passed by the collector for transferring the crusher unit, stone crusher unit, in the name of the petitioner, who is the widow, and the minor children are there, madam, which is in the name of her husband, deceased husband.
Husband was running the unit.
Yes, madam. That
He
was
died
in COVID-19.
He died on?
Died on my 23/7/2021 in COVID, my lord. That is, I have given that certificate also, my lord.
Now you want it to be transferred?
Transferred, my lord.
Any provision for transfer?
There is no provision in there is no provision either in the statute or in the government order, my lord.
Which statute?
Statute, my lord, that only that unity is to be established.
No, which law?
Law is, my lord, that crusher unit is to be established under the.
There is a central law, actually.
Yes.
Pollution Control Board permission and all other things.
My lord, pollution is there. You also kindly see the rejection order under.
I don't see all that. Now you have to convince me which is the statute
for establishment of crusher.
Yeah. Without foundational work, I will not hear the lawyers at all. You may be senior or junior. You should show under which statute the crusher units are established, which is the regulatory law. Is it that crusher stone crusher act?
No,
State Act or Central Act? We had the State Act, Central Act, I think it is. Law relating to stone crushing. That is how advocacy is.
No, it's my lord, but that question was not there.
Now I have arised. That is the first question. Advocacy.
You'll also keep it tomorrow.
Call it in the second week of 2026, or January 26. Yes, next.
Second week of
Item 49 have been at
January
52.
My lord, it is remain ideal, my lord. Therefore, after that,
the third week of December.
Item 52.
Yeah.
Does that matter? Your lordship.
Two companies.
Company is there, my lords, directors. We are basically moving today, my lords, the blacklisting of the directors, my lords. An interim order, your lordships did not hear on that date, my lords. Your lordship said that I'll hear it on a subsequent. So I'm moving that application, my lords. That is IA number 14090 of 25.
Can we hear the main matter itself?
Lordship fixes up a date.
Any date?
Tomorrow, my lords.
Tomorrow not possible. This requires a lot of time.
My lords, here my plea insofar as the directors is concerned, there is not a single whisper about the directors in the blacklisting process.
nor have they issued a show cause. Nothing has happened insofar as the directors are concerned. My learned friend has relied on Cox and Kings, my lords. That relates to a group company, my lords. Plus, my lords, there, even otherwise, my lords, even if Cox and Kings is taken into account, my lords, it entails, because your lordship is aware of the principles of natural justice, my lords, once someone is being blacklisted, it entails in a notice, a show cause notice to which he has to give a reply. I'm just giving your lordships an example. For example, let us say there is a director sitting in England, my lords. This is a multinational, I mean, these are executing works all across India, outside also. My lords. Suppose a director is sitting in England, my lords. He is not involved in this process at all. So if he would have been show caused, he could have given a reply. Now the blacklisting of the directors, the other companies in which they are serving as the board of directors, my lords, those companies are also being affected by this blacklisting. That is my only problem. Your lordships may hear the matter. I have absolutely no problem with that, my lords. My directors, my lords, without a show cause, they have been blacklisted. That is the urgency that I have. If that is stopped, insofar as the directors, your lordships, I may place all the documents. Your lordships will see everything relates to the company. And there, my lords, in Cox and Kings, the court says.
Just 2 lines.
No, I was articulating what you say.
There's one more development before the division bench.
Blacklisting, in the case of a company, is company specific. And it cannot extend to the directors, is your version.
No, my lords, I say if you feel, first thing is, my lords, my submission is the company.
Some development at the division.
There is a division where we have challenged the subsequent tender. Tender cannot be challenged before your lordships as it's a division bench matter. There, my lords, the matter is pending before the division bench.
I wanted to say, my lords, they made first attempt wherein, my lord, by a reasoned order, didn't grant interim relief. The second matter they are trying to move now. In the meanwhile, before the division bench, indirectly they tried the same thing. They said that let me submit. Division bench, they challenged the tender, saying that let this tender not be processed further till our blacklisting matter is heard.
So
that division bench list is also pending.
My lords, I am simply on this question of without the show cause. Can I be blacklisted?
As you fell from your lordship, let the main matter be heard.
My lords,
the first week of January.
My lords, the directors, I'm only involved with the directors, my lords, right now. Because the company matter, your lordships will hear it at length, my lords. I have absolutely no problem.
It cannot be bifurcated that way.
No, my lords. The directors, I'm just.
Because there is already an order made by me.
Yeah.
You are asking me to alter that.
No, my lords. There is no order. That is for the company. Company, my lords, I am not asking your lordships to recall the order, to modify the order. The only thing that I'm presenting before your lordship is without a show cause, can I be blacklisted? That is the only question, my lords. My lords, if you are blacklisting the directors, if you would have blacklisted me, if you would have issued a show cause, my lords, I would have replied. Then after whatever decision you would have taken, my lords, I would have been before your lordship. Whether that reasoning is correct or not correct, while blacklisting me, I understand, my lords. And my practical problem is, I am a director of a company, my lords. I sit in the board of directors of other companies. Those companies are getting affected by my blacklisting. The company matter, my lords, your lordships will hear it at length. And
how law relating to blacklisting of companies is treated?
My lords,
blacklisting in general, I know.
Yes, my lords.
Now, blacklisting of the company is treated. What is how the law has developed?
My lords, the law, if your lordship sees the facts in this case, if your lordship.
Just give the law. I'm asking for the development of the jurisprudential aspects.
Jurisprudential.
Blacklisting of a company for the directors. Blacklisting of the directors for the company. Blacklisting of company and the director. 3 parameters are there. How courts have treated this aspect? How foreign courts have treated? How Indian courts have treated? Those rulings.
My lords, then your lordships may keep the matter on Thursday, my lords.
This Thursday, very difficult.
This Thursday, Monday.
I'm not very. How many cases are posted on Monday? Monday.
Monday, I have a matter before this.
Tell me any day.
Any day
It only
after
reminds
the
me
first.
of the Solomon Grande born on Monday. When we were in primary school, secondary.
8 December.
8 December.
8 which Monday?
8 December is Monday.
So the next week I have matter before the Supreme.
8 December.
8 December.
8 December. Both the sides have chosen 8 December as the convenient date for hearing of the matter.
The entire matters or just this, the jurisprudence?
No, that is the only issue.
No, I'm talking about the directors. The main matter, my lords, that your lordships will hear it at length. But this directors, without the show cause, can I be?
The directors, my lords, were the signatories. They have given.
No.
We are also the company. They have signed.
The only authorized director has signed, my lords. Only the authorized director has given this.
IA stroke main matter. Application stroke main matter, whichever. Let us.
And let it come up in orders, my lords. For orders.
On IA, any
My lord,
application.
matters reach. No, all matters of my lord reach in court.
No, it reaches.
No, I may not be there on the 8th. Therefore, I have fixed that date.
My lord, then my lord may fix it to any other day. No, some other bench.
Let the other bench decide that. Yes. All right, matter on the 8th for considering the application filed by the petitioner.
Item 53.
Obligement.
We are grateful to you.
Yes.
Item 53.
My lord, item 50 for the opposite party BDA. My lord, kindly 2 weeks time I wanted to file the counter affidavits.
For filing of counter, 2 weeks granted. Call the matter of report. Yes.
Item 54.
My lord, 54 also, I'm for the university alerts against Utkal University. Opposite part number 4 and 5. This matter, my lord, I prefer time for filing counter affidavit.
3 weeks granted.
I am for petitioner. My lord, I am for petitioner. Interim order is kindly continue.
Interim order is there.
Yes,
but it is second week of this January. Interim order to continue. First matter also interim order is there.
Both the matter.
Same order. Yeah.
Oh, sub item is there.
The sub item also same. Next.
Item 55.
May please, your lords.
I'm on virtual mode, Miller. For OP 213 Miller. For personal difficulty, I could not be present physically, Miller. That is why I'm on virtual mode. I'm appearing for the opposite partner 213 Miller, the university.
2 and 3, university.
Yes, Miller.
Any urgency?
Yes, your lordship. The result is not published by the OUT, opposite party number 2, your lordship.
Sir, you have not published the result after students wrote the examination.
No, Miller, what has happened, your lordship by interim order directed to take admission subject to result of the writ petition, Miller. What has happened, Miller, a notification was issued for registration of the candidate within certain days, Miller, within 7 days without fine, after 7 days with fine, all that, Miller. All the students, they registered their name. When only the petitioner did not care to register his name, Miller. So as per the regulation, Miller, for the semester regulation, so the order has been passed to detain there. As per your lordship's direction, interim direction, he has been admitted, Miller, in the taken admission, Miller, the semester. But the result has not been published because your lordship has already directed that the admission shall subject to the result of the request. In your lordship, in counter we have filed, Miller. In counter page 12, his letter, Miller, your lordship may see the counter affidavit we have filed, page 12.
Page 12.
Page 12, Miller, annexure 3/2. That is the letter of the petitioner. I am writing to sincerely apologize and seek your kind permission regarding an issue with my semester fee payment. I sincerely
May I submit one thing?
You have apologized also.
Yes. Thereafter, I approached before your lordship directed to appear the examination. Thereafter, I have complied everything, your lordship. I have also deposited the late fee. May I place your lordship? Your lordship kindly see.
Except the payment of late fee.
Yes, sir. My lord.
Is there any other problem?
No, because the time was fixed, Miller. The semester regulation is there that he can register his name within 7 days, within 5, Miller. With fine. Without fine, there was a period. With fine, there was a period. He did not care about to register. All the students, they registered their name, Miller. The petitioner did not do it.
I understood.
Yes,
Sir,
Miller.
I understood. I understood. You are afraid that it may create a bad precedent for rest of the people.
Yes, that is what total counter is that, Miller.
What I
admitted in his letter, Miller, that is his mistake.
That's his mistake. Now, suppose without making it a precedent, as a special case, can you grant relief to him? I will say that this judgment is not to be treated as a precedent.
Your lordship can do it, but I cannot comment upon that. The university has no enmity with that student, Miller. But that the precedent here, as your lordship rightly pointed out, that will create bad precedent. Your lordship, that is the stance we have taken in the counter. That is the own admission of the petition that he committed the mistake. That is no mistake on the part. That is nothing illegal on the part of the university to retain the petitioner. That is what my submission is.
May I permit one thing, Your Lordship? Even if after cut off the date, they have allowed 3 students, Your Lordship.
You have allowed 3 more students after the cut-off date.
Your Lordship,
that is there, Miller. We do not deny, but he did not go there to consider his name. There is a group leader of everybody, Miller. Every student group there is. A leader is there. He said the group leader that I have already paid the fee. He did not go there. Unless he goes there, Miller, how his case will be considered, Miller?
No, not that.
He did not go there. He said that is his letter, Miller, that I have made the mistake. I did not pay the fee. I did not register my name. That is all his admission, own admission.
Anyway, you consider this as a special case?
Your lordship, I direct that we cannot. Yes, please.
So,
as your lordship, please, Miller.
Otherwise, he will be put to injustice student after all. Yes, no. Pray. Go to the prayer column.
But that may not be a create a precedent, Miller.
I will do that.
Yes, Miller.
Petition prayer makes out the grievance of the petition, grievance, and therefore it is reproduced. Next product. Learned counsel for the petitioner submits that there was a belated payment of fees, and in that connection, an apology letter is also tendered by his client. First, he points out that which court granted interim order?
Your Lordship.
This court, by the interim order dated
that is 13, Your Lordship, 13/8/2025.
Had said as under. He points out the interim order dated 13/8/2025, which reads as under. He also tells that, Learned counsel for the petitioner submits that right to education being a sort of fundamental right recognized under Article 21 of the Constitution of India by the Mohini Jain versus State of Karnataka. So, comma. Ordinarily, the approach of the institutions and the court should be pro-education, disregarding the procedural hurdles. First, he also tells that now, pursuant to interim order, his client having already written the examination, comma, the admission should be regularized, and the result of such examination should be announced so that he can prosecute the course in a wholesome way. First, next paragraph. Learned senior advocate appearing for the university vehemently opposes the petition by filing the detailed counter. First, he contends that when all other students could do the things in time, why admittedly the petitioner could not do remains a riddle wrapped in enigma, and therefore no relief can be granted to him. Contrary to the university regulations that prescribe the normative procedure for admissions of the kind. First, he also warns the court that directing registration of admission merely because an interim order has been granted by this court, pursuant to which the candidate has taken the examination, would be laying a very bad precedent. First, to this counsel for the petitioner retorts that already 3 more students have been given admission after the cutoff date, and therefore there is no reason to treat the cutoff date as a Portia's knife. First, next one, having heard the counsel for the parties and having perused the petition papers, this court, in the peculiar fact matrix of the case, is inclined to grant relief to the petitioner, broadly agreeing with his counsel submission. First off, petitioner, rightly or wrongly, could not limit the fees for the admission within time.
But you lost one thing. In 7th semester, he has already paid. I have annexed.
Although he has paid the examination fees for the 7th semester.
Yes.
First.
3rd year.
He has also tendered unconditional apology by the letter dated
that is
in the statement of objections.
Yes.
1825 million.
Which reads as under. First off, an honest apology ordinarily dilutes the guilt, says Bible. First off. Next point. The university is an instrumentality of state under Article 12 of the Constitution of India, while Ujjambai versus State of UP. Just give this. First one. State and its instrumentalities have to treat the citizens with soft gloves. Soft gloves. First one. Heavens will not fall down if petitioner's lapse is condoned, and his admission to the next level is regularized after accepting the fees coupled with the fine amount, if any.
Already accepted.
Accepted.
Yes.
First,
that info. Yeah.
This is this payment, learned counsel for the petitioner submits, is already remitted, and that his client has already taken the examination as well, pursuant to interim order. First, thus, justice of the case warrants regularization of the admission of petitioner to the next level and announcement of the results of the examination which he has written, so that he completes the course in a peaceable way. First, next paragraph. In the above circumstances, his petition is allowed. First, the university is directed to grant admission to the petitioner for the next level of the course.
Already admitted.
Admitted?
Yes.
That only thing is what?
Only thing is withheld the result of the system.
No, that admission is subject to outcome of the petition.
Yes,
No.
Yes.
What you have done? Course, first off, the result of the examination which the petitioner has written shall be announced forthwith to facilitate his completing the course in a usual way, subject to all compliances. Next paragraph. This learned council, one more learned panel council appearing for the university is more than justified in contending that whatever relief this court is going to grant in the judgment in the making may become a dangerous precedent, and therefore this judgment should not be treated as laying down any law of presidential value. First off, it hardly needs to be stated that the relief being granted in the peculiar fact matrix of the case, the petitioner, the counsel for the university need not have that apprehension approach.
May I pray one small prayer before you ask? Within a stipulated period, if
what they should do?
Announce the result,
With the house.
Yes.
Give no. Thank you, sir.
Oblige me.
Any urgent matter? My health is not that good.
Well, let it come next week because
next
56. Another 56.
All matters.
Yes.
59 item number 60, sorry, my lord, item number 60 is a content matter. And notice has already been issued, my lord, by 31st, 660, my lord, 60.
Yes, sir. I'm to take time, my lord. Some time may be given so that we can file. We have already sought for instructions from the field officers to pass an order. That should may give me some time.
Time for compliance I can give.
My lord.
But not for filing any objection.
No. I'm conscious, my lord.
Yes. 57. On the request of learned counsel, Mr. G, reluctantly a period of 4 weeks is granted for reporting compliance of the order in question, failing which the personal appearance of the contemners may be directed. In addition to levying costs in thousands of rupees, personally payable by them.
Item 57, Lordship. The matter related to construction of government work in the private land of the petitioner, Lordship.